Yes, what brings you here?
I want to move a matter.
Not the Thursday.
No, I want to move a matter. Yesterday, the judgment was delivered.
Give some time.
I will be completely dispossessed, Milord. Kindly let me allow come back at 2 p.m. Milord. I'll serve everyone and come. Milord.
No unlisted.
Milord, listed, Milord. I'll file it, Milord. The possession is today by the bank. I was not a party to the writ petition. Milord, a writ petition was surfacing.
Under surfacing.
Let me try my luck, Milord, today, Milord, at 2 p.m. or any time convenient to your Lordship, Milord. 4 o'clock, 3 o'clock, whenever it's convenient.
How can it be today, Mr. Water?
The possession is today. Supplementary list may be published.
Possession today?
Today.
Show us.
Yeah.
ওসব দেখবো।
Orderটা কোথায়?
Order of the Honorable Single Judge. It is not yet uploaded. It was delivered yesterday. Item number 4 of the 3 of the supplementary list.
We have also challenged we were the petitioners before the Honorable Single Bench.
You're the bank.
We are also challenging the same order.
He's tenant.
No, I am the company.
He's the company. We are the.
I am the actual borrower.
He's the borrower. I am the legal heir of the original guarantor.
Original?
Guarantor. The guarantor died, my lord. We have stepped.
Corporate guarantee must be a director. Director's son.
No, I'm not the director.
Director's son.
Daughter.
I indicate to your Lordship, it's not something very congenial on my part. Insofar as the facts are concerned, it's a bad matter. But I shall try my luck, not before the division.
Do you fix us? Complete service.
Yes. Service everyone. Service everyone.
But if you are not satisfied about the urgency, we
Very
will fix it in
very. I shall try.
Leave without this number copy.
দুটোর সময় রাখো একটা সাপ্লি বের করে দাও দুটোর সময় রাখো ওটা হয়ে গেলে অরিজিনাল
4টের সময় রাখো
We'll even then 3:30.
The bank will not come.
Kindly.
No problem.
3 p.m. will come back.
Today there is no 3:30 because today already the resolution is there, no adverse order. Great. Leave without certified server copy, leave with everyone.
Serve everybody. Otherwise,
He serve everyone.
make sure they're here.
সবাইকে সার্ভিস করবে।
Make sure they're
100%.
here.
100%.
Because of the resolution, otherwise we'll not.
100%.
May I be permitted, my lord? It's a two habeas corpus matter. My lord, let it be listed subject to lordship convenience on Friday, my lord. This is extreme urgent because Bengali speaking persons are arrested and their whereabouts are not known to us.
Not Friday, it will take
The only thing is, my lord, their whereabouts is not known to us. One minor is also there. Other mother, minor. And one mother, his son.
When did you file the appeal? You are filing.
This is ready. My lord, today itself we have affirmed affidavit. Everything.
Serve upon everybody.
My lord, will serve. Nowadays, my lord, is possible through email. And my lord, if subject to my lord lordship convenience is Friday, possible, my lord. My lord, because a habeas corpus matter, my lord.
What is the urgency?
Urgency, my lord, there.
I find in every matter you are disturbing us.
So, my lord,
Every matter you come tomorrow, you said tomorrow it has to be done, keep it today.
so, my lord, if it is habeas matter, if it is disturbance, my lord, I may
Why
be.
didn't you file your habeas corpus earlier?
My lord,
Then he was
after receiving information immediately, yesterday we have prepared it.
Information.
Yesterday we have prepared it, my lord, and affirmed it. From Birbhum they come here.
When did you receive the information?
My lord, the information received the day before yesterday.
So why
And they are coming from, my lord, the Birbhum, their family member. And yesterday we have prepared it and affirmed it, and my lord, approaching this honorable court. My lord, I may be excused, my lord. So far the habeas matter is concerned, my lord, the court is, my lord, ready, my lord, to be thrashed by the honorable court. But as far as habeas matter is concerned, it, my lord, hurts me, my lord. That being the situation,
you are
I am
so
no more. I will
moved,
no
you
more
are
come.
so moved.
And my lord, on Thursday, I have filed, my lord, habeas corpus matter that is yet to be listed. I took leave on that particular day, my lord, that is yet to be listed, my lord.
What is yet to
Thursday,
be listed?
my lord, the other two matter. They are arrested from the Odisha, and their
Which is-
whereabouts is not known to me. Yes,
is the-
only one mistake I have committed. The returnable date is, my lord, I have written 10th. One mistake I have
You will
committed.
not say your mistake at the inception.
No, my lord, the thing is this.
You will blame the court officer.
No,
but
my lord,
you will not
I am
point out-
not going to do that.
Don't mention.
I am not going to do that. Well, that being the situation, habeas matter, some
When
importance
you
is there.
started, you
Lordship.
didn't say I made a mistake.
Lordship.
You said that it mentioned it was to be kept today. You have not kept. You are alleging against
No,
us.
no, my lord. Thursday, Lordship was kind enough to suggest
Yes.
to
Why did you
fi-
give the returnable date on a different
to
date?
file. My lord, I may be
Admit your mistake
I-
first.
my lord,
First
admitting,
tell I am
admitting,
I am at fault.
admitting, my lord, admitting, but at the same time, department people.
Wait, stop. You are admitting that you are at
Yes,
fault.
madam,
Yes,
yes,
say that.
yes,
Say that.
yes, my lord. I admit it. I admit it, my lord. I admit it. It is my mistake. Returnable date is 10th July. My lord, our humble submission, my lord, subject to
Wait.
correction. Yes, my lord. My lord. I will be excused.
Nowadays,
Well,
it has-
kindly.
no, listen. Nowadays, it has become a trend to blame the court.
No, well, certainly not.
Because you did not mention your fault. You are not a toddler in the profession.
Lords,
You better be careful about your position.
lordship. Well, some
We,
anxiety.
when we were at the bar, we were taught that if there is a mistake on your part, tell the court first.
Yes, my lord. That is
But your training is not like that. Your training is go and say that the judge, you are at fault.
should not. My lord, they are picked up from the Delhi and other two matter from Odisha. They are Bengali speaking person, my lord, and their whereabouts is unknown to us.
কোর্টের সাথে তাহলে দিয়ে দাও।
Yes, my lord. Everything is ready, only filing. But I tender unqualified apology, my lord. In folded hand, my lord.
গ্রান্টেড এই লিভ গ্রান্টেড ফ্রাইডে দিয়ে দেবে এটা। না যেটা রিটার্নেবল 10 তারিখ আছে সেটা কালকেই দিয়ে দেবে।
And other two matter, my lord, the to be listed, my lord, in terms of by returnable date is 10th. My lord, in folded hand, my lord, I am praying apology, my lord. Kindly excuse me, my lord. I've committed mistake, my lord. It is better, my lord, to admit before this honorable court in a clear-cut language, my lord.
If the number to our court officer, it will.
Otherwise, my lord, they will not accept it possibly, my lord. Friday accept করবে?
Oh,
Friday accept করবে? Friday, my lord, they will not accept it possibly, my lord. Returnable time is less.
no, today we are on Tuesday. দেবে না কেন?
Well, possibly they will insist that to fix a date on Monday, my lord, to
কি leave
indicate a
দিতে
date on Monday.
হ্যাঁ অমলান কি লিভ দিতে হয়? Your relationship with the court, never think this way.
No, my lord.
We belong to the same family.
I know, my lord.
We feel irritated
I know, my lord.
when our brothers do not behave properly. It is not that I am having any annoyance with
No, my
any
lord,
person.
certainly not, my lord. I used to, my lord, make
Now
advance
the
argument
thing
in
is,
this court.
you don't understand the repercussion.
Lords,
The submission you are making,
lords.
behind you there are litigants standing.
Now, my lord.
And today is the now we are having online streaming.
Now,
In the evening it will come with a clippet that the
Yes.
judge was very angry. He said this thing. They will
certainly,
use the term angry, not annoyed.
my lord, my mistake, my fault, my lord. Once again, I
Careful,
repeat.
sir, you are not
True.
come to the profession yesterday.
True, my lord.
Be careful.
This is a
about
mistake.
it. Yes.
Apology, my lord. Unqualified.
For correction, my lord. It appeared for correction. We do not know why appeared. It's disposed of.
I can on behalf of the state response.
To appear for the petitioner, asked to question, my lord.
Yes, tell us.
My lord, the petitioner's daughter, my lord, is missing since December 2024. Though, my lord, steps have been taken, my lord, but till now is missing, my lord. No whereabouts has been, my lord, obtained.
What is the age of your daughter?
My lord, she is aged about 43 years. 43 years, but she is suffering from some sort of mental illness, but that doesn't occur that sometimes she is a normal kind of person, but sometimes she's having, and she's undergoing medication also. And but till 9th December 2024, all these 43 years, it never happened that he left for so long. He actually roams within the locality and everybody knows him.
Any development?
Lordship, may I humbly submit one thing? Since the very inception of this matter, whatever my learned friend has wished regarding publications and other, we have complied with that as per the order of the Honorable Court itself. Now, Lordship, the only difficulty in this particular case is that when she left over, there was neither a mobile phone or she was having any kind of iCards, that is even the Aadhaar card also. Now, tracking her was bit difficult, and we have to rely upon the source informations and places, including the medical officers of the concerned block officers, my lord. Now, it is not so that we are not pursuing with the matter, but our scope is very limited.
What can be done, Mr. Shamol?
Understand, my lord. May I humbly my lord, let this matter be handed over to CID, because what we have learned, my lord, CID have specialized mechanism to track, because they have much more expertise in finding the whereabouts of missing persons. What we have learned, my lord.
No, they are trying
My
their
lord,
best.
that in terms of the report, I cannot.
Then what purpose will be served by giving it to CID?
Because kindly see the anxiety the petitioner is of, and within this time she lost her husband, and 43 years person.
Now, this paper notification and everything
Everything has been
made.
done. Even there was a special request from my learned senior counsel only that Akash Bani should be informed regarding the missing also. That was also done, and it has been reflected in the order by the coordinate bench itself. Now, my lord, we are pursuing with the matter. We are not closing the investigation or anything. But our difficulty is that our scope is very limited, because we have to rely upon the source information or any information that we are receiving from the authorities to whom we have given later.
Any trace, any sort of
No trace, because we have collected those footages also that were in the vicinity just after the missing when it was complained, but we couldn't track it. Even some of the footages that were also missing, some of the footages for, because we have to rely upon the CCTV footages of the shopkeepers from the roads. That was the difficulty, madam. Now, Lord, when we inquired from the complainant itself, now there has been previous instances when she left away, again came back. Now, this was for the first time. It has been for a prolonged period.
pursuant to our earlier order, comma,
Your Lordship, Mr. Arun Kumar Maiti is appearing on behalf of Union of India. Your Lordship, praying for a short Passover. He's in court 26. He'll just come.
My lord, I am for the petitioner. That matter, illegal detention by the Union of India. My lord, I already hand over all my judge, my lord, written notes, judgment. Already 6 months, 1 year, my lord, detention order. Already 6 months elapsed, my lord. My lord,
If your Lordship
Any
can
query,
please grant a
Lordship?
short Passover, he'll just come.
any query, lordship, kindly ask me, and in the meantime, Mr.
Any
Any query regarding that matter, your lordship, last occasion, my lord, expressed your, my lord, that any query, I will ask you next occasion.
affidavits have been exchanged, Mr. Chattopadhyay?
Yes. Everything. Lady has 3 criminal NDPS cases. All cases,
Mr. Chattopadhyay, come next Wednesday. Let him come.
well, he will come. Well,
It will take
short
some time.
Passover, short Passover.
Not your Lordship. He is in item number 26 is going on in court 26. Just a 5 minutes Passover. He'll just come. Please.
Well, at item number 4, I am for the private respondent.
For the petitioner.
But this is my affidavit in opposition. No affidavit in reply has been served on me.
I am filing the affidavit in reply. দিলে তো দুটো কপি একটা কপি কোথায় আরে আরেকটা কপি কোথায় আরে জজ সাহেবের তো দুটো কপি হবে Where is the second judge's copy? Where is the second judge's copy? Ari, this is affidavit. Where is the second judge's copy? But it's affidavit in opposition is reply is ready. But it's my mistake, my lord. The second judge's copy is.
Well, the
I'll-
copy has also been served on
I'll
me.
serve it tomorrow.
upon the state.
Just take it up. Na, কি করো, my God. But I have a copy, but
Mr. Chakraborty, learned advocate appearing for the
State response.
Well, I'm led by Mr. Arun Bhattacharjee in this matter, my lord. I'm praying for adjournment. My lord, kindly fix the matter next Tuesday, your lordship.
What?
Lordship, this is a marital dispute matter. It is in connection to the custody of the child. Moreover, there has been no representation before the police authorities. And secondly, my lord, the marriage was dissolved by a decree of mutual divorce. And subsequently, in that divorce order itself, it has been reflected that the child
It
will.
was heard earlier.
No, my lord, this is for the first time.
Today you people have adopted resolution. What can we do?
As your lordship.
Next Wednesday. Next Wednesday, if an adjournment is taken, we
My
will
lord.
proceed.
Will address your
Keep
lordship.
this in mind.
My lord.
Yes.
I'm grateful. Your
Grateful.
Lordship. I appear for the state lordship, led by Mr. Mukherjee.
Next Wednesday. We pass over today. Next Wednesday.
Will I appear for the Respondent Union of India? তিনটে আছে তিনটে আছে তো আমাদের তো তিনটে আছে তো। তাহলে দুটো কেন থাকবে তিনটে করতে হবে।
Yes, place your case.
My lord.
কিন্তু তিনটে কপি করতে হবে
My lord, page 130 of the read petition,
এখন পর্যন্ত করেছি
order passed on 5th September 2024.
Page.
Page 130, 130. The Joint Secretary, Government of India, passed an order. I, Anupam Prakash, Joint Secretary to the Government of India, specially empowered under Section 3, subsection 1 of Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988. I am satisfied with respect to the person known as Jahanara Bibi, such and such, with a view to preventing her for engaging in illicit trafficking of narcotic drug and psychotropic substances in future. It is necessary to make the following order. Now, therefore, in exercise of the power conferred by subsection 3, subsection 1 of section 3 of the SHI, I direct the said Jahanara, my lord, detained and kept in Lokonayak Joyprakash Narayan Central Jail, Hazaribagh, Jharkhand. That order was passed on 5th September 2024. Thereafter, on December 16, 2024,
What is the next page order, Mr. Chattopadhyay?
my lord, that order on 5th September, along with that, my lord,
This is by the
grounds,
same officer.
yes, my lord, grounds on which detention order was passed,
Oh, acha. By the page 130, it was communicated.
my lord. That ground was communicated, my lord, later on. That
One
ground was
second,
communicated after 4.5 months of
No, no.
issuance of such order,
No, no.
not
Paragraph 11 of that order, page 135.
paragraph
11,
paragraph 11 of
page 135.
135. The above ground are communicated for the purpose of clause 5 of Article 22 of the Constitution of India. But that ground was communicated to me after 4.5 months. First, my lord, this order, page 130, 130.
So this page 131 memo was communicated to you 4 months later.
After 4.5 months, I have stated that. My lord,
Which paragraph you have stated?
my lord, that is page 130, page 131 to 135,
Hmm.
paragraph 10. Your petitioner said that thereafter, towards the end of January, while she was in detention, she was supplied a letter issued by the Joint Secretary such and such, dated 5th September 2024, stating the grounds on which she was detained. Again, in this contest as well, she was never supplied the said letter mentioning the grounds on her detention earlier. She was supplied the said letter only in the end of January, which is almost 4.5 months of issuance of such letter. That grounds was handed over to the detainee at the Hazaribagh Correctional Home. And thereafter son went there, and thereafter, my lord,
So it was given to the detainee. It was
detainee
presented
after
to-
4.5 months. After 4.5 months, which is almost after 4.5 months of the issuance of such letter, in the end of January. Considering the fact she was taken in detention on January 18, 2025. Order was passed on 5th September 2024. Thereafter, on December 16, kindly have a look into my note, December 16, 2024, the petitioner was detained by NCB along with local police.
Where do we get it?
My lord,
December.
December 16, 2024.
Where do we get it?
My lord, from paragraph 7 of my petition.
Go one by one, na?
Yes, my lord,
Go
sorry, my
one
lord.
by one.
Paragraph 7, first order 5th September 2024. Second, my lord, December 16, 2024. Petitioner was detained by NCB along with local police. And my lord went to, my lord, Jharkhand, Hazaribagh. But the authority of the state correctional home did not accept her detention on the strength of the order of September 5, 2024.
Where you have written that? Did
That
not accept her.
Did
for
not
detention.
accept. Jail authority did not accept. Said order was not supplied to the petitioner before detaining her from her house on December 16, 2024. Then he returned. She returned. Not accepted by the correctional home, she returned. Thereafter, on January 18, paragraph 9, January 18, at 12 p.m., police personnel connected to Bishnupur police station came to the house of the petitioner, and on the strength of the very same order, which is mentioned earlier above, dated 5th September 2024, passed by Ministry of Finance, again took her in detention, and thereafter again took her to Hazaribagh. My lord, thereafter already I have stated that the grounds of detention was communicated to me after 4.5 months. But what are the grounds? This is very important. Page 131, Lordship, kindly 1 second. Kindly have a look into the what are the grounds. My lord, practically, I am not wasting your time, my lord. Practically on the basis of 3 criminal cases, NDPS case, my lord, they, my lord, detain me. NDPS 03 of 2020, pending before the City Sessions Court. Another, my lord, TR 19 of 2023, my lord, they, my lord, here, my lord, mention, kindly have a look at 1.1, FIR 03 2020, Amasti Police Station case number.
No,
What
very
is, my
good.
lord? 1.1,
You got and bail in
all 3 cases.
all 3 cases.
All
you-
3 cases.
And cancellation of bail. was-
Cancellation of bail also cancelled, but not cancelled.
Cancellation of bail was filed in connection with which case?
My lord, that is supplementary affidavit. My lord, NDPS case number 04 of 2024, paragraph, page 14.
Page 14.
Page 14 of supplementary affidavit.
And in the other 2 cases, you
Other 2
obtained-
cases granted bail by Honorable High Court 1, and another, my lord, learned session judge. I have annexed
which, acha.
1 by 1, my lord.
No, very good. Now what happened? Cancellation of bail order is at page
14. 1-4. Got it, my lord?
yes.
My lord.
So yeah, cancellation was bail was rejected on 6th of March 25.
At that time, I already
You are in Hazaribagh.
correctional home, Hazaribagh correctional home. And my lord, they admitted I am on bail. That is page 131. All are admitted fact. No dispute. My lord, kindly have a look into page 131, 1.1. 1.1 C.
No. What is the provision under Article 22? This is communication in terms of Article 22, subclause 5.
My lord,
Let us see what is.
when any person is detained in pursuance of an order made under any law providing for preventive detention, the authority making the order shall, as soon as may be, communicate to such person the grounds on which the order has been made and shall afford him the earliest opportunity of making a representation against the order. My lord, the ground.
Tell us what happened. We understood. This order was communicated to you 4.5 months.
My
Then
lord.
thereafter what happened?
Thereafter, lordship, on merit, I am demonstrated before your lordship.
You argue later. Let us first know the facts.
And thereafter, my lord, well, what has happened?
136.
My lord, page, please. Page 136 to 138.
Page 136 to
My
136.
136. My lord, well, Joinal Sheikh, the son of the detainee, made a representation.
Mr. Chattopadhyay, there is no jurisdictional error in the issuance.
No.
So your argument is that though it is to be supplied to me contemporaneously, it was supplied after 4.5 months, and that is one of your grounds. Next
ground, the grounds taken by NCB are not at all, my lord, substance in this case, but no new ground. All are procedural law. That is, I am facing the trial. I am on bail. No new substantive, my lord, substantive reason in the grounds of the grounds passed by the, my lord, authority. All are procedural law. My lord, they are trying to keep me in the judicial custody, but the court of law granted bail to me. So new ground is required. New fact is required. Substantive fact is required.
It is provided under section 3(1) of the Prevention of Illicit Traffic Act.
My lord.
3(1) says that if the officer is the view that you need to be prevented from engaging in illegal traffic,
My
that
lord.
order can be passed.
My lord, that is for that reason I am relying upon so many judgments.
Tell us the facts, then
Facts, my lord.
gave a
Kindly
representation.
come to page 136.
This representation was 22nd January 2025.
By my son.
So if you have not got that letter, how could you represent?
My lord, I have stated in the paragraph 10, in the month of January, when I got the, my lord, thereafter I made the application, representation.
No, you said that 15 September memo was not communicated to you.
Communicated in the third week of January.
How?
I have paragraph 10, my lord.
You were taken in detention on 22nd December.
22nd December. My lord, said 22nd December, order passed on September.
September. Now on 22nd, when did you actually receive it? After detention.
After detention in the last week of January.
Thereafter your son made this representation.
My lord, that is 22nd January 2025.
Very good. Then what happened?
My lord, I have stated everything that I am on bail. My mother was on bail.
We will go to that. After that, what happened?
My lord, after that, on 10th February, that is page 142, through jail superintendent,
you made a
representation, but that was not probably accepted. But because by hand, when my son went there, they did not accept, and through speed post, my lord, my son, my lord, communicated to this representation to the through jail authority to the chairman advisory board.
That representation is by the convict, accused.
Accused
And
without
the first representation is by
signature,
because
because
she is in
that
jail.
time he was in jail. They are not permitted to sign.
All right. Then what happened?
Thereafter, my lord, detaining authorities supplied all the documents relating to 3 criminal cases against the petitioner relied upon by them in the instant detention order, page 146 onward. 146 to 288. All 3 cases, they supplied all the documents.
When?
My lord, that is also in the month of February. The exact date not possible for me in view of the fact all the documents supplied to my mother. And when after 1 week, 2 weeks, son went to the jail, thereafter they supplied me. Page 146 to, my lord, 288.
Then what happened?
Thereafter, my lord, page 11 of the supplementary affidavit.
Page 11.
Advisory board passed an order. My lord, for that reason, section 9, kindly have a look into first section 9, my lord. For the purposes of subclause A of clause 4 and subclause C of clause 7 of Article 22 of the Constitution, central government and each state government shall, whenever necessary, constitute one or more advisory boards, each of which shall consist of a chairman and 2 other persons possessing the qualification specified in subclause A of clause 4 of Article 22 of the Constitution. Save as otherwise provided in section 10, the appropriate government shall, within 5 weeks from the date of detention of a person under a detention order, make a reference in respect thereof to the advisory board constituted under clause A to enable the advisory board to make the report under subclause A of clause 4 of Article 22 of the Constitution. Thereafter, the advisory board to which a reference is made under clause B shall, after considering the reference and the material placed before it, and after calling for such further information as it may deem necessary from the appropriate government or from any person, call for the purpose through the appropriate government or from the person concerned. And if in any particular case it considers it essential so to do, or if the person concerned desires to be heard in person, after hearing him in person, prepare its report, specifying in a separate paragraph thereof its opinion, advisory board opinion, as to whether or not there is sufficient cause for the detention of the person concerned, and submit the same within 11 weeks from the date of detention of the person concerned. Where there is a difference of opinion among the members forming the advisory board, the opinion of the majority of such members shall be deemed to be the opinion of the board. Next, a person against whom an order of detention has been made under this act shall not be entitled to appear by any legal practitioner in any matter connected with the reference to the advisory board and the proceedings of the advisory board and its report, excepting the part of the report in which the opinion of the advisory board is specified, shall be confidential. In every case where the advisory board has reported that there is, in its opinion, sufficient cause for the detention of a person, this is not an order, this is an opinion, the appropriate government may confirm the detention order, may, and continue the detention of the person concerned for such period as it thinks fit. And in every case, where the advisory board has reported that there is, in its opinion, no sufficient cause for the detention of the person concerned, appropriate government shall revoke the detention order, cause the person to be released forthwith. So, my lord, confidential, and it is an opinion.
But the opinion, accepting the opinion, the other parts will be confidential.
Confidential.
Opinion can be
Can be communicated.
So this opinion will be sent to the appropriate government for the purpose of extension of the period of detention.
My lord, my lord. Thereafter, the order passed on, opinion passed on page 11.
Page 11.
Here, my lord, with due respect, I am submitting, my lord, three sitting judge of the Jharkhand, one sitting, honorable sitting judge and registered general are the members of the, my lord, advisory board.
A sitting judge is a member.
That is, my lord, Honorable Justice Rangan Mukhopadhyay, Judge, High Court of Jharkhand, Ranchi.
All right. What is the opinion given?
In pursuance of section 9B of the preventive detention such and such, I am enclosing herewith 3 sets each of the following document in respect of such and such who has been detained.
No, this is being sent to the board, advisory board.
This is the reference.
This is the reference. Deputy Secretary is sending it to the board.
Board, my lord. Reference.
Then on 4th of February.
4th of February.
Then where is the opinion?
My lord, that opinion not with me. That is, my lord, sorry, my lord, that opinion, my lord,
that opinion will
not with me, my lord.
Huh?
Yes, Deputy Secretary, Government of India issued a reference in respect of the petitioner. And page 21, kindly come to page 21, my lord.
Yes.
Deputy Secretary,
Page 16 is a representation made by whom?
Page 16.
Is on your behalf an advocate has made. 13th.
Well, advocate. My
13th March.
My lord.
Requesting to communicate the status of the representative.
My lord.
That was earlier. Now
page 21.
Yes.
With reference to the representation dated such and such, no merit, rejected. Deputy Secretary. And thereafter, page 22. Kindly come to page 22, 4th paragraph from the top. Whereas the central government has considered the opinion of the State Advisory Board, Jharkhand. And whereas, 3rd paragraph, matter of Jahanara Bibi was placed before the State Advisory Board, Jharkhand, which is of the opinion that sufficient cause is made out for detention of the detainee, such and such. And whereas the central government has considered the opinion of the State Advisory Board, Jharkhand. Now, therefore, in exercise of the power under section 9F of the Act, central government hereby confirm the above said detention order dated 5th September 2024 and further direct under section 11 of the said Act for a period of 1 year. For a period of 1 year.
Yes. Now, where is the opinion?
But that opinion not with me. That no, never, my lord. No.
Opinion, is there any provision under the Act that the opinion has to be communicated?
No, that is only central government has considered the opinion of the State Advisory Board. From here, I came to learn my prayer was rejected.
Under the Act.
Under the Act, my lord.
There is no provision.
My lord, why they are stated only opinion is not confidential.
Yes, opinion is not
Confidential.
but it has not
Not been,
given.
my lord.
So now you are before us challenging this final order of detention for 1 year.
for 1 year.
What are your grounds? Tell us now your
My lord,
grounds.
My lord, my lord, the detaining authority, my lord, regarding my lord,
Grounds for confidence.
we used to my lord, see the bail order. We used to see the bail order of 3 cases rely upon by the my lord NCB. Kindly come to page 55. In my lord, page 55, it is relating to NDPS case number 03 of 2020. My lord, in the note I have stated everything, my lord. It is 03 of 2020, page 55, relating to the order passed by the Bench 1 City Sessions Court. That order, my lord, relevant portion, page 55. My lord, record is put up, petition for bail of accused Jahanara. It is submitted further that accused in JC since 4th January 2020, learned PP, and third paragraph, having heard both sides after careful perusal of the case record, it appears the investigation of this case was concluded in filing charge sheet.
Why you are showing us that? It is
That
an admitted position.
the admitted position, and not only that, that I am showing because of the fact, last portion, your lordship know, my lord, in when your lordship in the bail jurisdiction, there are some conditions in bail order. Surety and once in a week with until further order before the magistrate. If the detainee was detained, how he comply the order of the court of law?
For non-compliance.
My lord, kindly have a look into the position. Why they pass this type of order? So that the detainee was detained for an indefinite period. When after 1 year she came to the house, he came to learn that NDPS 3 warrant issued. Again, she went to correctional home. This is the practical problem, my lord. I am saying, my lord, on ground level, what are the problem in criminal, my lord, jurisprudence, my lord?
Now this cancellation application was made in connection with which case?
My lord, cancellation application, I check with 1 second, my lord, page 14 of supplementary affidavit. That is NDPS case number,
Who of
my lord, 02, my lord. There are 3 cases.
Relates to NCB case, ma'am.
Yes,
This
all
relates to
3.
one of the cases, Miller, which relates to NCB. case.
04, my lord, 04,
Yes,
my lord, that is
0202?
NDPS case number 04.
No, no.
Yes, that is that number NCB crime number.
Yes, yes.
NDPS case number, got it, my lord, this portion, NDPS case number 04, page 14.
That is corresponding to paragraph 1.3.
That is corresponding to paragraph 1.3. And that order, 115, bail order. That case bail order, NDPS 4, 115.
So your argument,
Bail application is both sides. 45 days is in recovery of 7 kg of ganja. And
now, now what is your argument before us?
my lord, the detaining authority.
What one argument you made that all the 3 matters I was in bail, and in the third matter, cancellation of bail was moved on behalf of NCB, that was rejected.
My lord,
This is one.
my lord.
And if you are kept under preventive detention, you would not be able to comply with the bail conditions given.
And conduct the trial, fail to conduct the trial.
Now, does that even if you get bail, you cannot be detained in a preventive detention
My
under
lord.
the statute?
Get
There
fully,
is
your lord.
such bar.
No bar.
No bar.
My lord.
Then
Then my submission.
yes.
Yeah.
What is your submission?
My lord, there is no subjective.
One submission of yours is what we found from the papers, that when Supreme Court judgment was relied upon, saying that the NCB himself went for cancellation of bail. Cancellation bail was granted. Then what is the additional pedestal on the basis of which you are detained?
My lord.
This is your
Yeah,
argument.
my lord. Subjective
Now-
satisfaction. Subjective satisfaction. That word was used by the Honorable Supreme Court also. Subjective satisfaction with a view to prevent the petitioner from engaging in illicit trafficking of narcotic drug in detention order. That subjective satisfaction is a condition precedent of passing a detention order. According to Honorable Supreme Court, I am relying upon my Lord Sushant Kumar Bonik versus State of Tripura, reported in 2020.
Yeah, just.
Subjective satisfaction, objective satisfaction. Subjective satisfaction. Subjective satisfaction দরকার, তাই তো?
20
এগুলো বের করে নিলাম।
page 5 of my compilation. First, thereafter judgment. My lord, judgment starts from Sushant Kumar Boni. Starts from page 8.
Yes.
My lord, paragraph 23 to 30. My lord, 11 portion.
সব ছিল। এই তো সব এখানে আছে তো,
My lord, as noted above, In the case on hand, in both the cases relied upon by the detaining authority for the purpose of preventively detaining the appellant hearing, the appellant was already ordered to be released on bail by the concerned special court. Indisputably, we do not find any reference of this fact. The proposal forwarded by the Superintendent of Police West Tripura District while requesting to the process the order of detention. The reason for laying much stress on this aspect of the matter is the fact that the appellant, though arrested in connection with the offence under the NDPS Act 1985, the Special Court Tripura thought fit to release the appellant on bail despite the rigorous of Section 37 of the NDPS Act. Section 37, Lordship, no. My Lord, thereafter, my Lord, paragraph 27. From the above discussion, it emerges that requisite subjective satisfaction, the formation of which is a condition precedent to passing of a detention order, will get vitiated if material or vital facts which would have bearing on the issue and await the satisfaction of the detaining authority one way or the other, and influence his mind are either withheld or suppressed by the sponsoring authority or ignored and not considered by the detaining authority before issuing the detention order. Thereafter,
no, you summarize your arguments. Your arguments are as regards this fact was not taken into consideration. 3 bail applications, I was in bail, cancellation was refused. That is why the detention, according to you, is not sustained. Let us hear the
one or three, only one judgment I referred, my Lord. Lord, kindly allow me, my Lord. My Lord, thereafter, my Lord, kindly come to preventive detention order under PIT NDPS Act.
In your case, was any proposal sent by the police authorities to?
No, nothing. Not in the record.
Not in
that I flouted the condition passed by the court of law. Never. Then, my Lord, next judgment, 2021 9 SCC, page 415, page 17, my Lord. Ponka Sea Sila. My Lord, here, paragraph 11, 15, kindly come to paragraph 11, my Lord. Then 12, while it cannot seriously be disputed that the detainee may be a white collar offender as defined under section 2X of Telangana Prevention of Dangerous Activities Act, yet a preventive detention order can only be passed if his activities adversely affect or likely to adversely affect the maintenance of the public order. That order, that
is factual.
Thereafter, my Lord,
On facts, my Lord.
come to paragraph.
Mr. Chattopadhyay, this Bonka Sneha is not applicable in your case.
Ratio, kindly come to page, kindly have a look into paragraph 15.
Yes.
There can be no doubt what is alleged in the 5 FIRs pertain to the realm of law and order, in that various acts of cheating are ascribed to the detainee which are punishable under the 3 sections of the Indian Penal Code set out in the 5 FIR. A close reading of the detention order would make it clear that the reason for such order is not any apprehension of widespread public harm, danger or alarm, but is only because the detainee was successful in obtaining anticipatory bail or bail from the court in each of the 5 FIR. If a person is granted anticipatory bail or bail wrongly, there were well-known remedy in the ordinary law to take care of the situation. The state can always appeal against the bail order granted or apply for cancellation of bail. The mere successful obtaining of anticipatory bail or bail order being the real ground for detaining the detainee, there can be no doubt that the harm, danger, or alarm or feeling of insecurity among the general public spoken of in section 2A of the such and such act is make believe and totally absent in the facts of the present case. To tear these observations out of context would be fraught with great danger when it comes to the liberty of a citizen under Article 21 of the Constitution of India. The reason for not adopting a narrow meaning of public order in that case was because of the expression in the interest of which occurs.
Proposition is what you showed us in the earlier case, that there has to be a subjective satisfaction.
My lord, then my lord kindly come to
Paragraph 15, this reference was also there, but this judgment subject to be corrected by you is not identical on facts. That was created state order.
my lord.
Now, this judgment, the principle of law which can be called out is that there cannot be detention in the absence of any subjective satisfaction of the board.
My lord.
And the board also need to have taken into consideration the fact that you are in bail, cancellation has been rejected.
My lord.
Now you have given various judgments.
Various judgment.
Let us hear him now.
My lord, okay. Only one thing, my lord, I want to say before your lordship.
And only to show, my lord,
দাঁড়াও না, বসো না।
so that we can precise them.
তোমার বলার পর তো আমি বলতে পারবো না, তাহলে আমাকে শেষ করতে দাও।
রিপ্লাই দিতে পারবে
না, রিপ্লাই বলা যায় না জাজমেন্ট।
তো বলো চারখানা মামলা।
My lord, নোটটা দে। My lord, if your lordship kindly come to page, my lord, page 41 on my compilation. Page 41 onwards.
কম্পারিশনে দিয়েছো আমাকে?
দিয়েছি। Page 41 প্রথম পাতাটা দিয়েছি, জাজমেন্টস অফ রিপোর্টেড।
Yes.
মানে নোটটা দেন, এখানে নোট এখানে। Page 41, my lord, paragraph 6. This is our High Court judgment, 1970 Criminal Law Journal. No, sorry, my lord. That is, my lord, Supreme Court judgment, my lord, page 41, paragraph 6. আমাদের হাইকোর্টের জাজমেন্ট করে গেল।
No, how, Mr. Chattopadhyay, what are the grounds of detention?
My lord,
that is not known to you.
No, irrelevant, my lord.
Ground, once we see the grounds, then we can check now whether it is relevant.
My lord, their ground. Their ground, I have, my lord, page 131.
He show us that. Then.
That is page 131. Already, my lord,
Joint Secretary order of 5th September.
Advisory board ground. Advisory board ground, they call for the record. Otherwise, my lord, in other matter also, this court, my lord, call for the record in one matter. In code number.
Can we do so in view of section 9? Section 9 says.
But court, with due respect.
Opinion will not be confidential.
My lord.
But the opinion is a one-line opinion.
My lord.
What are the grounds behind that opinion that is not known to us?
My lord, that I may cross that, my lord, your lordship, the question, can he do so? That is, my lord, in one judgment of
Finish off page 41, paragraph 6 first.
paragraph 6. B, there is no doubt that if any of the grounds furnished to the detainee, that is, grounds means detaining of sponsoring authorities ground, that I have already mentioned page 131. Grounds, my lord, kindly 131. That is the grounds on which detention order, page 131.
So this has been accepted by the advisory board.
Yes, my lord. That grounds,
Show us the ground then.
my lord, that page 131, their grounds, 1.1 FIR.
Yes, 1.2 again FIR.
FIR. Thereafter,
1.3
again FIR. And H, 1.28, they all cases they admitted I am on bail. Thereafter 3, page 134. I am aware that at present,
where did you find age?
age means, my lord, 1.2 age, 133, page 133. They admitted.
Now come to
Paragraph 3. I am aware that at present you.
Paragraph 2 first.
Paragraph 2. After going through the facts and circumstances in all mentioned cases, it is clearly established that you, such and such, are actively involved in trafficking of narcotic drug. That was already reviewed by court of law. Court of law. My lord, sorry, my lord. You are a habitual offender. Your presence in the society is a threat to innocent person of the locality, state, nation, and your activity are prejudicial to society. I am aware that at present you, such and such, are on bail. However, considering your conscious involvement in illegal trafficking of drugs and psychotropic substances in a repeated manner to the detriment of the society, you have a high propensity to be involved in the prejudicial activity in future. Apprehension. or paragraph 6. But there is no doubt that if any of the grounds furnished to the detainee are found to be irrelevant while considering the application of clauses I to Roman 1 to Roman 3 of section 3(1)(a), and in that sense are foreign to the act, the satisfaction of the detaining authority on which the order of detention is based is open to challenge and the detention order liable to be quashed. Similarly, if some of the grounds supplied to the detainee are so vague that would virtually deprive the detainee of his statutory right of making a representation, that again may make the order of detainee invalid. If, however, the grounds on which the order of detention proceeds are relevant and germane to the matters which fall to be considered under section 3(1)(a) of the Act, it would not be open to the detainee to challenge the order of detention by the arguing that satisfaction of the detaining authority is not reasonably based on any of the said ground. Thereafter, kindly come to this judgment, my lord, Pushkar Mukherjee versus State of West Bengal, page 15 and paragraph 15. It was, however, argued by Mr. Debabrata Mukherjee on behalf of the respondent that even though ground number 2 may be vague, the other grounds supplied to the detainee are not vague and full and adequate. Page 48, paragraph 15.
You were placing page 50.
I am placing the judgment starts from page 41. Pushkar Mukherjee versus State of West Bengal. Starts from
Page 41 is
Pushkar Mukherjee. Got it, my lord? My lord.
Other paragraph.
In other paragraph, last paragraph, page 48, paragraph 15. It was, however, on behalf of the respondent, even though ground number 2 may be vague, the other grounds supplied to the detainee are not vague and full and adequate particular have been furnished, but it is well established that constitutional requirement that the grounds must not be vague must be satisfied with regard to each of the grounds communicated to the person detained subject to the claim of privilege under clause 6 of Article 22 of the Constitution, and therefore, even though one ground is vague, the other ground are not vague. Detention is not in accordance with procedure established by law and is therefore illegal. My lord, thereafter, kindly come to page 50. Page 50, here, my lord, point is that none of the activity of the detainee which forms the basis of the detention in the page 50. My lord, page 50, AIR Online 2024 SC 915.
Yes.
My lord, that judgment, paragraph 4.2. First paragraph, my lord, the fact. Paragraph 4.2, detaining of basically 6 cases registered against the appellant by State Excise Department. Grounds of detention were communicated to the appellant. Detention order was approved by the Home Department. Confirmation order by the government of Maharashtra. Several grounds were raised in the petition, including the ground that there was no nexus with the alleged activity of the appellant and the order of the detention, in as much as there was a gap of about 2.5 months between the proposal of detention being forwarded to the detaining authority and the detention order being passed. It is also submitted that such and such. Thereafter, kindly come to page 7, paragraph 7. Paragraph.
Those are the 6 cases.
My lord, 6 cases. 7 to 10.
Yes. Now, which paragraph you are?
My lord, basic proposal of detention is passed. Paragraph 7, page 51. Chart, 6 cases chart. Then,
Which is the relevant portion?
11, my lord, paragraph 10, my lord.
Mr. Chattopadhyay, here the case is
My lord, in this case, my lord, in paragraph 16, my lord, last paragraph, my lord, page 54, in the present case, all 6 cases are regard to selling of illicit liquor. Those 6 cases are registered. Excise authority did not find it necessary to arrest the appellant, even on a single occasion. It would have been a different matter. Had the appellant arrested, thereafter released on bail, then again the appellant continued with activity. However, that is not the case here. In so far as
that
statement
is applicable in this case. That will be there now.
that is no.
Once
Thereafter,
bail granted, you will again start offending.
but thereafter, paragraph 18, in view of the above matter, we do not find the subjective satisfaction of the detaining authority, that activity of the appellant. No subjective satisfaction. Last judgment I have already, my lord, submitted before your lordship all the judgment in paragraph wise. Last judgment of our High Court, my lord, that is
Is in those 3 cases,
my lord,
trial has
page
started.
64, page 64 to 87, page 64,
To 87.
page 64 starts from page 64. My lord, the honorable coordinate bench passed the order. That matter also your lordship, my lord, deals in primarily that time in code number 31. My lord, thereafter, my lord, ultimately, my lord, page 64 kindly come to that portion, that whether the court can, my lord, call for the record of the advisory board. My lord, jurisdiction of the invoke, petition is checkered history.
You appeared.
My lord. My lord, kindly come.
Paragraph.
My lord. My lord, 1 second, my lord. 38. To 38. My lord, paragraph 34, page 75. The legislature has used the word satisfy.
Yes.
The legislature has used the word satisfy. It appears to the court on the basis of the available record that formation of such opinion was tainted with malafide, bad faith, improper, unreasonable, and intolerable exercise of power. My lord, my lord, before that, kindly come to page 68.
Yes.
My lord, paragraph 5. My lord, skip it, my lord. Accordingly, the detention order was passed on 1st April 2021 for a period of 1 year. Got it? Petitioner made a representation to the advisory board. Since the order of advisory board is confidential, we directed the authorities to produce the original file containing the report of the Central Advisory Board under the Prevention of Illicit Traffic Substances Act 1988. For that reason, my lord, I am searching, my lord, that portion. My lord, and ultimately, this petitioner detainee was released by this honorable court. My lord, detention is an exceptional mechanism. On that point, my lord, that mechanism,
There is no ambiguity as regards the proposition of law.
no, sorry, my lord.
The only thing which is to be determined is whether the opinion of the advisory committee on the basis of the grounds disclosed was justified or not.
My lord. And another thing, my lord, I want to mention before your lordship.
Asking a question, the grounds which were mentioned in that, you will find that it has argued that there is a propensity of committing an offense.
My lord, that portion I may cross over, my lord. Lordship, kindly page 6 of my compilation, Roman 10 and judgment, that is Nebnath Buji versus State of Telangana. The satisfaction cannot be inferred by mayor's statement in the order that I have quoted, my lord, that paragraph, my lord, that judgment.
That was relating to the public order under the State Act.
Hello, all preventive orders or preventive detention, state or central.
Let us hear him. Anything in reply you may.
My lord, another judgment already I have, my lord, submitted. Recent judgment 2025, Dhanam versus State of Kerala. Here also, page, paragraph 3, my lord, 5 crime.
Paragraph 6 টা পড়ো।
Thereafter, my lord, paragraph is on bail. Paragraph 8, whether preventive detention of the detainee is in accordance with law. Here all judgment, my lord, referred Rekha Murtaza Hossain Chaudhary, I already referred, my lord, 9, 10, Pankaj Sneha Sila, paragraph 11, paragraph 12, my lord, paragraph 18 also referred Nebnath Buji. And thereafter, it is, my lord, kindly have a look into last, keeping in view the above exposition of law, we have no doubt the order of detention cannot be sustained. The circumstances pointed out in the order by the detaining authority may be ground enough for the state to approach the competent court for cancellation of bail. But it cannot be said the same warranted is preventive detention. We clarify that if such an application of cancellation of bail is made by the state respondent, same must be decided uninfluenced by the observation made herein above. My case is better.
Lord, my learned friend has taken so much time, my lord. Lord, during his submissions, my lord, it may be my limitation. I failed to understand what are the grounds of challenge. First of all, taken in the writ petition.
Sir, where are the grounds on the basis of which opinion?
My lord, I am coming to that, my lord.
Do you have that?
I will call for the records then, my lord.
Then
My lord, preliminarily, my lord, to understand.
narrows down to the issue as to whether the grounds, whether they were malafide or whether unjustified. So unless we see the grounds, how can we determine this fact, Mr. Mike?
Before that, my lord, I will do that, my lord. If your lordship, my lord, is pleased to, my lord, direct me, sir, we are to comply with this, my lord. My lord, before that, my lord, coming to the ambit of the scope of the act, my lord, my learned friend said so much, my lord. We are to go into the, my lord, preamble to the, my lord, act, why it was, my lord, enacted. Whether
Grounds in page 120.
my lord, I am coming to that. I am coming to that. My lord, he has taken so much time.
Now, where page 134 written by the Joint Secretary, are these the grounds of the advisory board?
My lord, before coming into that, my lord, whether the writ petition itself is maintainable in the form it is filed. Kindly consider also that. And also thereafter, my lord, whether the grounds, my lord, he is alleging now by
Instruction, Mr. Mikey, that whether the grounds which are because your
in our affidavit in opposition, my lord, we have dealt with everything, my lord. Elaborate, my lord, dealt with, my lord. And my lord, if thereafter, my lord, after going through that, my lord, if lordship is not satisfied, my lord,
we have already hearding for
no,
45.
because, my lord, I have not taken only, my lord, even 10 minutes time, my lord.
You say that yes, everything is with me, we are here.
My lord, just, my lord, my lord, after going through the affidavit in opposition and the materials placed, my lord, if your lordship is satisfied, my lord, not satisfied, that these are the grounds, my lord, has to be your lordship have to be satisfied, my lord, then, my lord, I can, my lord, obey your lordship's, my lord, direction, my lord. I can ask the, my lord, call for the records, my lord. My lord, now, my lord, the basis object of, my lord, the Preventive of Illicit Traffic in Narcotic Drugs and Psychotic Substance Act, my lord, the preamble to it, my lord, just, my lord, I am submitting, my lord. My lord, in our old days, my lord, subject to your lordship's, my lord, have vast experience, my lord. It is our duty to place the, my lord, either to support or to oppose, my lord, to place the facts before this honorable court. Thereafter, my lord, to formulate the points, my lord, of law on the basis of which we will argue, and to argue substantial, my lord. My lord, the act to provide the detention in certain cases for the purpose of, my lord, I am not going into that aspect, only the peripheries of the act under which he was detained, and the detention order was confirmed. My lord, if your lordship, my lord, sufficient time has been, my lord, taken, my lord, I know, my lord.
Yes.
If your lordship, my lord, thinks, my lord, that it will be taken up on some other day, my lord, I can, my lord, or 3 p.m. or 3:30 p.m., my lord, I can start. Because if I start, my lord, I would take some time. So, my lord, I do not want to consume much time, my lord, because others are waiting in the queue, my lord. Very important bench, my lord. So, my lord, if I start, my lord.
We are wanting to know whether you are equipped today to answer these queries.
My lord,
Maybe having a very reasonable case. We are not on that.
yes.
But we are putting you a question to you that Mr. Maiti, whether this opinion which has been formed, those grounds are known to you. We have not passed any direction asking the advisory board to give it to you.
My lord,
We want our counsel to check up.
my lord, that I will check up. But we have tried to deal with everything in our affidavit in opposition, but we cannot disclose it because it is a confidential one. If your lordship, my lord, wants to production of the, my lord, things before.
We are not asking. If you can satisfy us, well and good. Huh?
I can demonstrate the case, my lord, under what circumstances this detainee was detained and further order of detention was substantiated on the basis of the materials placed before the advisory board, and the advisory board formed an opinion for his further detention, and the detention was for 1 year. That point, my lord, possibly is there, my lord. But, my lord, if after that, my lord, if your lordship is kind enough.
Opinion is to be, cannot be a one-line opinion. Nah? It has
No, my
to
lord.
be supported by reasons.
Yes, my lord, that production of documents must have been there, my lord. Otherwise, to form an opinion, my lord, because one judicial member was there, two other administrative members were there, they must have come to the satisfaction, my lord. My learned friend is arguing, my lord, subjective satisfaction, not, my lord, argued, my lord, objective satisfaction, my lord. All the judgments refer to my learned friend, my lord. When I will reply, my lord, I will give answer to all the, my lord, judgments, my lord. My lord, my lord, not objective satisfaction has not been contemplated in the act itself.
To whether the grounds which you have stated in page 134 of the 134, the order of the Joint Secretary of 5th September, whether these are the same grounds on which the opinion was formed. Must be.
Must be. We'll have to check up there. I have to, as a lawyer, I have to check up. Because, but
You please check up and tell us that whatever page 134, kindly come to page 134. This paragraph 3 onwards. This must have been the grounds for the formation of opinion.
my lord, other materials are also there, which I have also dealt with, my lord. My lord, in my affidavit in opposition, my lord. My lord, apart from that, my lord, involvement in the, my lord, case, my lord, about 40 lakhs unaccounted for accounts, my lord. These are based on records, my lord, collected, my lord, by the, my lord, authority, my lord, for the purpose of detention, so that, my lord, these accused person detainee before your lordships may not be involved in such type of, my lord, illicit trafficking of drugs and or, my lord, narcotic drugs, my lord. Now, therefore, my lord, I was to, my lord, trying to harp on the issue, my lord, not, my lord, other law and order, my lord, other acts, my lord. This is different acts, my lord. We have to know the preamble of the act, my lord, which necessitated, my lord. My learned friend has not placed any facts before your lordships, my lord. And the advisory board, on the basis of facts, circumstances, materials on record, which was supplied by the government, whether they have come to a satisfaction that, this detention order will continue and confirm the order of detention for 1 year instead of 2 years, he confirmed it for 1 year, my lord.
Alright,
Now for
so what you are showing?
my lord, kindly have a look at my lord. My learned friend has not placed anything on facts, neither his reply or not on facts, my lord. So my lord, kindly don't allow him, my lord, to make any argument on facts which he can take before your lordships, either in the writ petition or in the my lord affidavit in reply. But one paragraph, my lord, my lord, I am just submitting one paragraph, my lord, just my lord, for your lordship's consideration. So these are the materials, my lord. One of the materials I am paragraph, my lord, page 10, paragraph 7, my lord. In reply to my learned friend's, my lord, contention that she is an innocent drastic lady. Backdrop of the case, my lord, I will come up again. With regard to paragraph 1 of the said petition, I do not make any comment to the extent that detainee being the petitioner here in the region of India or this a permanent resident of the address given in the custody of this petition. But I deny her contention that she is a rustic lady, but the fact remains that during financial investigation of the case, my learned friend has never, my lord, placed anything either in the yes, my lord. It was found that she has assets worth of 46 lakhs along with one plot of land which is identified and was frozen as illegally acquired assets from the sale proceeds of the drug under the provisions of the NDPS Act 1985. Therefore, her innocence pose does not have any room for sympathetic consideration in the given facts and circumstances of it. I have, my lord, just, my lord, quoted one of the paragraphs in my opposition, my lord, that, my lord, there are certain materials, my lord. We have to, my lord, make ourselves confined to the peripheries of the preamble to the act itself, my lord, whether within the ambit and scope of this, my lord, preamble with reference to that, my lord, how far we have proceeded and how far the materials we have collected for the purpose of detaining a citizen of India. And, my lord, then, my lord, we have to come before your lord, before, my lord, my learned friends should have, my lord, enlightened, should have, my lord, placed this, my lord. What is the, my lord, definition of illicit?
Anything else you want to show from the affidavit?
My lord, everything I will show, my lord, just one paragraph, my lord, just to show, my lord, that objective satisfaction, my lord. Definition clause, my lord, which, what is, my lord? Illicit traffic. Section 2(e), my lord. Definition clause of the act, my lord. Illicit traffic, my lord, first of all, my lord, because we are to satisfy your lordships to the hilt.
Where
Your-
from we come to know your allegation in page paragraph 7?
Paragraphs.
Paragraph 7, which you have just now
Yes.
placed, that the fact remains during investigation, it was found she has assets of 40.
Place the records. We will place the records. We will, we will place the records if your lordship so wants, my lord. We will place the records.
Sir, we are not wanting. We are asking you, how do you substantiate? Don't pass the buck onto the court.
No, no, my lord, I am not saying,
We
my
have
lord.
asked you a simple question, that this statement which you have affirmed on oath, this is on what basis?
This is on the basis of the investigation and the materials collected.
Sure, that you should have referred to it, that this was the report. Only rustic lady having land, having money. What is the basis of this affirmation? You have affirmed paragraph 7 as true to your knowledge. On what basis you have affirmed? What is the knowledge? Where from did you get this? Paragraph 7 is on the basis of your knowledge. On what documentation you have this knowledge?
I will present it before your lordship, my lord. The investigation of the case. The super assets and the investigation which was found
This is what
details.
we are
Yes.
asking you, that
Yes, my lord. The details, my lord.
argument we have followed.
Yes, my lord.
Now, we have not made up any mind
No,
in
no,
this.
no,
in
my lord.
favor of
Your lordship
because
never
it is
does
a
it.
very,
Yes.
very serious
Very, very.
allegation which you are making.
Yes, my lord.
That when the competent court in NDPS under section 37 observing that he had overcome the rigors,
No,
have
because,
granted the bail.
no, because that was not, my lord, these are commercial quantity, my lord. Your lordship knows, but in intermediate quantity, my lord, bail is granted.
Intermediate quantity.
Yes.
So that sets a higher pedestal for you. Whether there is any recovery of any commercial quantity from
Commercial quantity is also there. My lord, if it is whatever, my lord, I will also argue on that point, my lord, whether, my lord, grant of bail.
we are wanting to you have what is falling from us. There has to be subjective satisfaction on the basis of the materials on record. So the advisory committee, we are not directing you that you produce the advisory committee now. If you can satisfy us on the basis of these materials, this opinion is to be formed. You go through the opinion.
My lord.
You go through the
My
opinion and tell us that no, there is. We are also aware it is an advisory board which has been set by a sitting member of High Court.
My lord.
So, the High Court judge.
Some satisfaction should have been there.
That is what we are.
That is very much expected.
You go through that report.
My lord. My lord.
Yeah, we heard Mr. Chattopadhyay learned that.
Yes, on behalf of the appellants, my lord.
New method.
New method.
First time.
First time. Lord, I've served, my lord. I've checked up, my lord, the state and the private dispute.
You are there.
Mrs. Juma Chakraborty is appearing for state. Mrs. Juma Chakraborty is appearing for state, your lordship. She is appearing online, your lordship.
Just tell us what is the message.
Now, my lord, on 19th of December.
Have you completed service upon private?
Yes, ma'am. I've checked up, my lord. All the track report showed the item delivered upon address.
19th of
December 2024. There was an assault on the petitioner, my lord. Assault on the petitioner as well as her husband. So, my lord, on 19th of December, same thing repeated on 20th of December. We went up to lodge a complaint, but before that, the assailant, my lord, they has also lodged an FIR. There was FIR and counter FIR. Charge sheets had been filed. Now, my lord, after the incident, my lord, the petitioner, the appellant has to be admitted in a hospital. And for the,
The habeas corpus.
no, my lord,
Oh, this is not
no,
a
no, no, no.
habeas.
It comes out of a police inaction, group 9, my lord.
But private respondents are not here, sir.
No, my lord.
Today you are having a resolution.
Yes, well, I know that, I know.
Come tomorrow.
Tomorrow, my lord.
Tomorrow. Take back your affidavit of service.
My lord. Grateful.
Trial number 8, I beg to appear on behalf of the appellant petitioner, my lord. Lord,
It's your other side.
Lord, we have sought
Any private respondent? Any private respondent?
yes, there are 6 private respondents. My lord, only thing, my lord, instead of adjourning the matter today, my lord, some incident had happened after the passing of the order by the honorable trial judge. My lord, kindly grant us leave, my lord, to file a supplementary affidavit.
When was the order passed?
My lord, the order was passed
Oh, fine.
on, my lord, 11th of April 2025. The order was passed on 11th of April of this year. And, my lord, we had adjacent 17 decimals of land that was, my lord, covered by a boundary wall. On 20th May, my lord, they broke down entire boundary wall. My lord, so we have photographs, GD, and we will, my lord, just kindly grant us leave, my lord, so that we can file a supplementary affidavit incorporating those things, and we'll serve other side and come. দাঁড়াও সব যেটুকু বলতে দাও, আমি তো আজকে কেউ নেই এমনি শুনবেন, আর যদি 15 দিন পরে ফিক্স করে নেন তাহলে no, not yet affirmed, my lord. Kindly give us leave so that we can do it.
Subsequent event.
Subsequent event, my lord.
You have served the copy of the
Read petition, my lord. Read the copy of the memo of appeal as also, my lord, the application for stay.
That is upon 6 to
12. Yes, my lord.
what is appearing 6 to 11.
But in the trial court, there an advocate appeared, my lord, for them.
You are there.
Well, in this matter, I am led by Mr. Bimal Kumar Sai for the state.
Kindly see the order, my lord.
You do one thing. We are keeping it. Let the private respondent appeal. Then we will bring the documents, whatever you have.
Yes.
That supplementary file will take you again back for 2 weeks.
Oh, my lord can adjourn it for 2 weeks. In the middle, we'll affirm the affidavit, serve it, and come.
2 weeks. Yes.
I'm grateful, my lord. Affidavit, my lord, affidavit of service be kept. I'm grateful.
This is my application, my lord.
Respondent, writ petitioner, the copy of the appeal has not been served.
My lord, we have tried to serve them there. It's come back as unclaimed. The affidavit of services here, my lord.
Oh,
They
but
refused to accept it.
from a writ petition.
Yes, of
I
course.
don't know if it's been
Kindly
served
see
on the lawyer. Advocate appearing.
come back as I'll serve them and come back. I have no difficulty in serving. That's all.
You have copy, Mr.
Yes, my lord, I'll do it immediately.
Lord,
You
could
come back
just-
tomorrow.
Instead of tomorrow, could it be on Monday, my lord? The writ petition has been finally allowed. Declaration of fraud of my account has been set aside. So if instead of tomorrow, if it could be on Monday.
You're for the bank, Mr.
Yes, my lord, I am for the bank. But there's a delay of 84 days, my lord. I've tried and explained in paragraphs 3 to 7, my lord. I'll of course serve them and I'll have to come back.
That section 5 you have given.
No, my lord, we have tried to serve, it's come back as unclaimed. So, my lord, we'll have to serve now physically on them, my lord.
Monday.
So great.
Did I oppose this appeal, my lord? But I am for the respondent, my lord.
He's opposing you.
My lord, Railways, my lord, is the appellant, my lord. They appeared on the last occasion, my lord. Very
Yes, next.
I am for the appellant, man.
Appellant. You are for the appellant?
Yes, man.
You are for
Respondent.
respondent?
Private respondent, my lord.
Private respondent. Who is for state? What you are looking at?
I serve my law, all the respondents.
My brief, my lord.
My
I-
You have lost your brief.
No, only I have intimated by the client on phone call to attend this court, my lord. That's
When
what,
will you get it?
on 10:30, my lord.
You will get it today.
I will get it today, my lord.
Come tomorrow. Yes, tomorrow. Next,
All evidence is filed, man.
give it tomorrow.
All right.
You take instruction, come back. Yes, next.
That's good.
Same.
Yes, my lord. My lord, I am on behalf of the appellant, my lord. For the respondent, my lord. My lord, I'll file up on supplementary, my lord. Some photos been taken 7th, my lord. Day before yesterday, my lord. The stock of the sand is already there. It can be seen, my lord. The matter is in regard to, my lord, my land is there. And
Supplementary,
Oh, sorry.
you have given
Two copies are there. My lord, the stacking of the sand is there on my land. And that is already been, my lord. I'm not able to do my cultivation also, my lord. In this case, what has happened, my lord? The entire my livelihood has gone, my lord. So day before yesterday, that the state has already denied, even the private respondent has denied that they got out the NIT for mining of the sand from the river, my lord. Now they had kept out the entire sand on my land, and that was done out by the authority by forceful means. So they denied out in the opposition that no more in inspection, my lord. There is no sand into that. But still also, I took out the photograph on 7th. The supplementary can be taken, my lord. The supplementary, it has been the photograph on 7th, it has been taken.
Are we supplemented? Yes, that is the procedure which is usually.
My lord, but thing is there, my lord, but it's a fact, my lord, they had denied in the opposition.
First of all, Mr. Banerjee
Yes.
is for respondent number 12.
12.
What?
My lord, I'm serving the copy.
Impugn order is of 30th of January. 30th of January.
Yes,
impugn order. Sir,
Direction
is it an
fact.
appealable order? It's only for direction of affidavits.
My lord, the exchange of, but the thing is there, my lord, the inspection which was done, it was never been carried out into that. We challenge out why the sand was lying. There was been, because I'm not doing my agriculture, it's very urgent because for last 8 months, I'm without my livelihood. I'm without my livelihood from November 2024. If the exchange of affidavit takes place, in several years is going to take place, and entirely my land will be a barren land. We people are a
Make an appropriate prayer before the single judge. File a one-page application and have.
my lord, we had made our submission there, my lord.
Have you made an application there?
No, my lord, there I did not make, but
You are the respondent in the writ petition.
no, my lord,
He is the
petitioner.
petitioner.
We are the petitioner. We are the landowners. We are the doing agriculture.
Now, Mr. Banerjee's argument was recorded that they were acting on the basis of a tender work order. Now you say that in the guise of such order, they are extracting more.
No. They are keeping the extracting of that sand from the river is being kept out in my land, which is my agricultural land, which is they were given by the authorities, my lord. If their opposition is taken, they also had admitted into that. There was a deadline.
Before the writ court, you said allegation was they were illegally extracting sand.
Extracting was the sand was there. But we don't know exactly what we think out is illegal because when they keep it in our land, so altogether.
Understand.
May I take 2 minutes of your lordship's time? I mean, just the basic facts. The writ petitioner's case was that my clients were illegally extracting sand and keeping it on his land. This was the writ petitioner's case when before the trial court, and because of which he had written to the police authorities that nobody is taking. But his case was I was extracting the sand and keeping it on his land. That was it.
Who are you?
I am, my lord, I'm coming to you. Let's just give me 1 minute. Lord, I appeared over there and I said that I am not a person who extracts sand. What happened was illegal sand mining had happened, which was confiscated by the district administration. Thereafter, the district administration published a tender. When I have a tender with me, I was a successful tenderer. I have not kept it. These sands that were lying in various lands, I was one of the persons who was the successful tenderer. So I got the tender, and by now I've removed the sand.
Tender was for removing the.
Yes, which had been illegally mined by somebody else.
So his case is that illegally mined sand was somehow dumped into his area and which you are removing.
He said I was illegally mining
Now
and keeping it in his land. That is his writ petition case.
Now he says something different.
Now it's different, but his writ petition case was I had illegally mined and kept it in his land. But the actual fact is I had not done any mining. I was successful in the tender published by the administration, which says that illegal mining sand was being auctioned off. So I was successful, and in any case, the entire sand which I was awarded in the auction, I've removed it.
Even from his land?
From his land also. There is no other sand left. I have the pictures over here. If somebody else's land, I don't know. But as far as his land, I have already removed the sand. I have pictures. That's why, because they said yesterday on the last occasion, they made a submission before the court below that sand is still there. That's why I asked them to take a photograph. Now I have the photographs here. That I've already removed it from his land. And in any case, this is a writ petition for police inaction that was filed.
Mala, the entire sand still is being there, which we took out the photograph day before yesterday.
So, sir, you can easily make an application that, my lord, what has been stated here in the order is that the subsequent things which are happening. Such cases you pass an appropriate order. We are in appeal, na?
Yes,
if we reject your appeal, you will be having a difficulty in going back to the trial judge.
Yes. Make it an app.
That you should accept what we are saying.
No.
But we are thinking. Your allegation was that sand was being illegally extracted by him, and it was being after illegal extraction. Why they will keep the sand? They will sell it off.
My lord, even in the writ, even if I say the opposition is not there before, but I'll just put up. They say out they were to remove within a deadline. As per the NIT, they were to remove the entire sand within a deadline.
So you are aware of the NIT that they were supposed
to. No, they admit that they have
Deadline.
not removed.
So you are aware.
My lord, they admit they did not
And
remove
you
that.
didn't object when the sand was kept on your land. If you're so aggrieved that you can't cultivate the land, why didn't you not oppose when the land was being the sand was being stored?
My lord, can I find out with the authorities? Can I find out with the DM? Can I find out with the?
It's not for us to answer, Mr.
Yes,
Counsel.
my lord.
So you should have opposed. You could have come
We
to
have
court.
opposed, my lord.
You
That's
came
the
to
reason. That's the reason we
So you
came out
came
for
to
a writ,
court.
my lord. When police were opposed to that, that's the reason we came out with a writ, my lord.
Acha, tell us what was your story.
My lord, our story was that now these private respondents, they have been doing illegal sand mining and they kept it in our agricultural land.
So sand mining illegally done from your land?
Not my land. That is Sonrekha River, my lord.
No. They have extracted that sand from whose
From
land?
the river, my lord, and kept it in our place.
From the river.
Yes,
And it has
and kept it in our place. And we wanted that to be removed. We asked the police authorities
That
to
is
act
removed.
upon. The police authority did not act upon.
So your argument was opposed by him, that I am not keeping anything, I have not.
But they have admitted in their
Right.
opposition.
They have filed an opposition. You will file a reply, and the matter will be heard out on that basis. What urgency you have?
Well, there was one statement made by the state that there is nothing lying there.
Mr. Agarwal, you decide. We can say this that you can withdraw this with liberty to approach the single judge, or if you want to argue on merits, we will take it. We have not also gone in.
Well, I'll make out one application for appropriate order, my lord.
Before the single judge, then you have to withdraw the appeal. Huh?
But my lord, thing is, if I say I'll file out this opposition also, because the opposition they have admitted already they have kept out the sand within the deadline. They did not remove that sand. My lord,
Withdraw the petition, go and file an appropriate application along with a prayer for expeditious discourse. Yes. We record that.
What should be done? My lord, can it be kept to tomorrow? I'll just take out an instruction, my lord. If an instruction can be allowed, I'll take out the instruction from my client, my lord. Then I can, tomorrow if it can be kept, my lord.
Then day after tomorrow.
Yeah.
Day after tomorrow.
Yeah. In course of hearing, the learned advocate
Wait a minute. This is the case.
is the first time it has come.
Shall I serve and come back? Shall I serve and come back?
No, contempt, no.
Contempt appeal. The case, my lord, contempt application was, my lord.
My lord, I don't have the copy of the.
My lord, he was appearing before the learned single judge, my lord, all along during
My
the
lord,
hearing of the contempt.
But I have been, my lord, this matter is allotted to me, my lord, for appearing on behalf of the, my lord, respondents, state.
There is the order, contempt. We cannot record your presence today.
Yes.
Once service is effected, then you can.
Lordship.
Yes, which order violation you are seeing?
No, my lord, the lordship kindly come to page 60. No, appeal, it's an appeal.
Which page 60?
Page 67, the original order.
Appeal from an order passed in court.
10th of May 24 order.
No, 20th November 2020 order. Page 67, 67. No, my lord, at the outset, my lord, have you lordship got this matter, my lord? Your lordship sitting as single judge, single bench, my lord, took up the matter, my lord, but in continuation, but in it's a, my lord, release of my lord area salaries. Lordship, while setting aside one of the order of the authority, my lord, that I am leaving it to your lordship, my lord. But my lord, thereafter, my lord, some other order was passed, which is
Ground of one of us.
because my lord, that is recorded in the order itself.
I first ordered in your favor months.
Yes. Once order was set aside, remanded back to authority, authority passes further order. That was set aside by the order under challenge.
Oh, I see. Yes, next. 15. Fine. You're for
I appeal the respondent.
contempt.
Contempt.
There was direction for service.
No, this is my lord, an appeal from a contempt. My lord, dismissal of a contempt. My thing is the appeal is not maintainable. Lordship knows section.
Dismissal of contempt. How is it appealable?
Not appealable. That is what I'm saying.
No order of punishment.
No order of punishment. The learned judge found that the order had been taken by misleading the court and has dismissed the contempt proceedings with costs.
How much?
Yeah, amount is not much, some 1100-1200 rupees. So my first point is, and only point is, that is not maintainable under section 19.
Anyone appears today on behalf of the appellate, though Mr. Banerjee.
Yes, Lord.
This is suo motu contempt appeal against the suo motu under section 19.
Order was implemented.
Yes, because on the day 23rd, it was the last working day of the High Court. An order was uploaded in 8 p.m. Therefore, there is no scope for right to appeal. It is a statutory right, and sentence suspension is also a statutory provisions contained in Article 19, but there was no provision. But I'm not confident it has been implemented. The point is that why I filed this appeal is a question of law involved in this appeal. The section 14 has been invoked. Section 14 can be invoked as per latest Supreme Court judgment passed in retired Supreme Court and High Court Judges Association versus State of UP. In an extraordinary situation, it can be, and what are the circumstances that has also been refined. Second position is that it is barred by the limitation because the rule has been issued after 1 year. Latest, so therefore, it is a required hearing because that has been over. Because Honorable Supreme Court in different order, I challenged the order and asked me to.
Mr. Chakraborty, what remains in the appeal?
No, but why? Because the stigma is there. Whether the recording of the observation, which is not palatable, is a criminal contempt or not, number one. Number two, whether after 1 year, what is contempt in the face of the High Court or Supreme Court has been defined by the Honorable Apex Court in Leela David's case, and subsequently, latest decision passed by Honorable Justice Dipankar Datta and Honorable Justice Sanjeev Khanna that it has to be, section 14 can be. Second point is that whether after 1 year, and without any trial, whether punishment can be inflicted. I know that there is nothing on that point. Kindly see the date.
Remove the defects and come.
What is the report, madam?
Go to the stamp reporter's report.
Well, what is that? Because there is a why I am telling.
Stamp reporter's report. Something you have to incorporate. You correct it and come.
Well, one thing, because
correct the defects which have been. Have you seen the defects?
No, I'm just let me see because there is some confusion over the file.
And come.
Well, let me see the defect. What? Then I can explain why this is. Where is it?
Do I have to find out that page for you?
Page, pardon?
Do I have to find out where you will find the defects?
I will not find.
Yes, we will do that. We are here for that, na?
Just you put next time could not find it.
Next Thursday. Yes.
But next time I will not be here because I have fixed it to. Well, why I am because problem is that in filing a appeal under section 19, as per 1961 Supreme Court verdict, that it shall be in the name.
Chakraborty, when an appeal is filed, it goes to the stamp reporter. stamp protectors checks up whether there is any defect.
I know that part, but I know that part, but
So
he,
you remove the defects.
no,
you
my
will
love,
take-
here, why the confusion? I tell you, let me. It is a coming under.
There are certain defects which have been pointed out. Unnecessarily, you are making submission. Next Thursday.
Kindly, this is after 18, well, after 17, because I have fixed the.
Chakraborty.
My lord, I appear for the appellant.
I appear for the respondent.
My lords, have heard this matter at length on last two occasions. Madam, last order, my lord had recorded my argument has been completed.
I was to address your lordship. This is regarding, my lord, the policy in Salt Lake, whether, my lord, the policy of not allotting more than one land tomorrow.
Tomorrow we take it.
Madam?
Tomorrow we take it.
Tomorrow.
Then we have a matter fixed, madam.
My lord. My lord, some precedents or it will appear.
Pardon?
My lord, some precedents may be given in this matter.
আচ্ছা এটা তো শুনেন বলে একটা ডিল বলে দাও how much
No, no, I'll take, my lord, 15-20 minutes more, not more.
শুক্রবার গতকাল পার্টনারশিপে finish it.
Lord,
You tell your time. We keep it is in foreigners. We will keep it for
Lord, tomorrow, my lord. Because I only have to, my lord, produce, your lordship directed me to produce the, my lord, affidavits. They have sent me this copy. I'll get it by, my lord, today 2 p.m. I'll get the copies. 2 affidavits by the, my lord, original lessee and the substituted lessee. I'll furnish that and I'll make my submission.
We keep it tomorrow.
Tomorrow.
Tomorrow foreigners that you put it.
Smile. My lord.
Mr. Speak to be empty Mr. Sharda, your original segment.
Well,
The thing is, there was a mentioning from us as
so
regards.
after that, about my matter.
He wanted to tell you because you would be coming at 2 p.m., but we have fixed this matter for this. Once it gets this over, we shall. Yes.
Yes, Lord, the matter which much meat. Lord, the matter which Lordship Lord has
All for one.
allowed Lord, Lordship Lord, my learned junior Mr. Bhattacharya mentioned in the morning, Lord, citing urgency at 1 p.m. Eviction notice was issued. Lord, I am for in the second matter, I appear on behalf of the appellant in that 2 leave was granted, Lord, separate.
Yes,
2
yes.
matters. Kindly, Lord, permit me to proceed, Lord.
Yes, yes.
Now, Lord, before I tell you, Lordship, Lord,
Which one? Your matter is
second one, Lord.
Sarvamangalam Gajana. Sarvamangalam Gajana.
You are in that matter.
Yes.
You are in the
Lordship.
and in the first one.
My lord, I am for the appellant, my lord. Led by Mr. Srijeev Chakraborty, my lord, he is in the virtual mode. না আলাদা
My Lord, Lordship should kindly, Lord.
আপনি দুটো
Who is opposing?
Lord, we have served.
Still you are opposing.
Let's say I'm opposing you, but only difficulty is that your lordship, very at the 11th hour at lordship, voluminous papers, whatever the facts I am ready with yesterday's fact.
Stay your hand still.
But the bank has already taken physical position.
After
Position has already been taken, your lordship. I have the photographs. At 1:15, the execution has already been done.
we had mentioned in the morning,
At 1:15.
my Lord's granted leave
It was process was started in the morning, concluded at 1:15.
after granting the leave.
Lordship, but the only predicament before your lordship, my predicament is that I was not ready. However, the appellant before your lordship in the mat.
My Lord, today
Notice was
after
not served.
my Lord, leave was granted to move it at 2 p.m. My Lord, we informed them.
At 1:30 I have received. At 1:30.
Informed কাকে দিয়েছো? Informed to the advocate কে দিয়েছো? Informed to the learned advocate appearing for the bank. Yes. Notice টা দাও কটায় পেয়েছেন ওনারা?
My lord, I have served my appeal at 12:48 p.m. to Mr. Singh over WhatsApp.
That is
Soft copy.
already executed.
Soft copy. And I have personally
They left the
informed
place
Mr. Singh.
1:50.
Mr. Singh, that the matter leave has been granted. Kindly tell your officers, inform that the matter will be taken up at 2 p.m. That was my personal matter. I can give an affidavit to that effect also.
Yes, I'm not
I have
disputing. I'm not
Yes,
disputing. The
even
position
after
of
that,
the does not
even
arise.
after
My
that.
advocate on record says, my Lord, prior to serving this formal notice in writing, WhatsApp message was sent.
Yes.
Because it is given at 12:50. What was the position there? We are also at your
Absolutely, my Lord.
Not.
But thing is, my Lord, point is very short, my Lord.
Had it been an issue, point is short, we will consider.
Right of appeal under section 17, my Lord, has been denied. Right of appeal under section 17 has been denied. I have a statutory right of preferring an appeal.
That's factually incorrect.
একটু বলতে দাও।
What is this? Is it a
Surface
commercial area?
Position, let's say the photographs regarding position, I have asked to substantiate that the position has already been taken over by the bank. Let's kindly see.
My Lord, I had obtained loan.
Is it a flat or a building or what?
Flat.
Flat.
Residential flat.
Residential flat.
Residential flat. Residential flat.
So it was a vacant flat at that junction.
My Lord, flat belonged to the guarantor, my Lord.
So tell us what are the facts?
I tell your Lordship. My Lord, I appear on behalf of a company. Company.
You have got the copy of
No.
the server?
No, my Lord, we have
has also not been served, yes.
We have pleaded that in paragraph 13, and we have got, my Lord, the YouTube version, my Lord. Lordship can seize the order. In paragraph 13, we have narrated the order. Practically, by the impugned order, my Lord, the paragraph 13 of the writ petition, my Lord, at page 42 of the stay petition. Order under section 14, my Lord, practically been implemented. And I have a right of appeal. Paragraph, my Lord, 13 at page 42 of the stay petition.
অরিজিনাল বড়
কালকে তো ওরা রিপিটিশন করে
কালকে রিড করেছে ভাই তাই
হ্যাঁ হ্যাঁ
এখন পাঠিয়ে দিয়েছি
হ্যাঁ আচ্ছা
And kindly, my lord,
Who filed the writ petition, Mr. Dev?
my lord,
Who filed the writ
my
petition?
lord, the guarantors. I am the borrower. I tell you, lordship.
You're related.
Yes,
So if the writ petitioner guarantor did not make you a party in the writ petition,
I'm not on that. I'm not on that. Directors were made parties in the individual capacity. I'm not on that at all. I'm on a different point, my lord. My lord, a notice for eviction was affixed at the premises. They want to take possession.
notice for eviction.
No, yes, that I will be evicted. That's
But it's access right under the Surfacy Act by the district magistrate.
Notice of possession.
page 110 is the notice which was affixed. Now, my lord, this step was taken, my lord, in
Who are you?
I am the borrower, my lord.
Who are the
I have obtained loan, the company.
You obtained loan or your
I obtained loan. I obtained loan.
But in the order it is said that the mortgage has expired.
Let's say they have not challenged the Surfacy action, they have not filed the writ petition.
Petitioner and the private respondent are siblings.
Yes.
Respondent number 5 is the husband of the deceased mortgager.
My lord, there are 3 guarantors. They are all family members. It's a private limited company.
Company.
Sorbomongola. Sorbomongolam Gajalan Street Private Limited. The company obtained loan. 3 ladies stood as
What was the loan amount?
31 crore. Initial loan কত ছিল তাই তো
32 lakhs
32
crore
32 crore
31 crores approximately. They have encashed a security which is about 4 crores. My lord, I could not pay. This fact I cannot dispute. Now, my lord, initially they issued a sell notice. This was the second one. Now that was withdrawn when I challenged it before the DRT. The borrower challenged it. That I have made an averment, and that order has been annexed with the stay petition appearing at page 49. Now, what had happened, the guarantor out of three, one lady who is the sister stood as guarantor. Brothers are the directors, sister stood as guarantor. She passed away. Her heirs came in. They had certain disputes with the directors, the brothers of the mother who passed away. Already a civil suit has been filed. That is not the subject matter of the dispute. Now, my lord, at that juncture, my lord, they issued another notice. Prior to this, two other writ petitions were filed at the instance of the guarantors. Orders have been passed, and time was given to file a section 17 appeal. Now, at this stage, the issue is, my lord, they have given this notice, which notice was challenged, my lord, for sale or to take possession. That is appearing at page, my lord, 111.
Sale has been confirmed in whose favor?
Nothing has been confirmed. Kindly comes to
Sale
page
has been
111. Kindly come to this page 111, which I have challenged.
Yes.
111 does not speak about selling. Kindly come to page 111. This is the confusion. Page 111. আমাকে একটা সেকেন্ড বলতে দিন
Legible, sir.
that I know there is a difficulty
No, should tell us now.
it's a notice.
Allegedly, it was sold by the bank to whom?
It has not been sold. It has not been sold. What they have said at the top, handing over possession. So they asked me to hand over possession. 110 at the top. Subject, handing over possession. Lordship has got it, my lord. Subject, handing over possession. RE account, the name of the appellant. Lordship has got it. Kindly see at the top the date mentioned of the notice. Yes. Now the contents of the notice. Kindly, my lord, may I read it out? I know, my lord, I apologize, my lord. There was an order passed under section 14 by the district magistrate in continuation of the 13-4, my lord. They approached and the order was passed.
By which you are hereby advised to hand over. Who? You means who?
My lord, RE, name has not been mentioned at the top, my lord.
At the top, all, everybody.
The company at the top, left-hand side. So the company was directed to hand over possession. Pursuant to an order passed under section 14, which is in continuation of section 34.
Then what did you do?
I tell you, lordship.
No, but Mr.
Now,
Deb,
kindly.
Mr. Deb, this handing over of possession is of the same flat that they've taken possession.
Yes.
That doesn't belong to the company.
That doesn't belong to the company.
The notice
Belong
was
to the
given
borrower.
Notice was given to
The mortgager. The mortgager.
But notice given to us.
to the company.
Let's say the mortgager has died. After the death of the mortgager.
Notice is not given to the mortgager. Notice that you have given.
Let's say the legal, yes, kindly see the notice. Kindly see the notice. All the left-hand side is the borrower. Right-hand side is the legal heirs of the mortgager who deceased.
Possibly, my lord, it was given because they are
Let's say
related.
kindly legal heirs of such and such, Kedia, who is the mortgager. And thereafter the son and husband are in the era of addressee.
Okay, then thereafter, yes, Mr. Dev.
Now, my lord, kindly comes to page 111, the order passed under section 14, when learned district magistrate was approached. Pursuant to this, my lord, this notice was affixed. And lordship would find at page 113, it's a little bit technical, for the district magistrate. District magistrate did not sign it. And section 14, my lord, says only the district.
111 is of a preceding date.
Yes, preceding date. Preceding date. After that order, my lord, they asked for possession. I did not do anything, so they approached the district magistrate. Let me take the best case what they have.
So what interim order do you want?
My lord, I would go and approach under section 17. That is the statutory right of appeal that I have. Good vibrant, that right cannot be taken away. Now, by this order, the impugned order, practically, my lord, the order has been implemented. So I want stay of this for a period of fortnight. In the meantime, I would approach under section 17.
Under section 17, there's a timeline for
45 days.
45 days statutory
Yes,
period.
measures taken. Kindly, I was showing the date. Measures taken, my lord.
For June.
Yes, absolutely, my lord. Measures taken, language of 17. Absolutely, I'm grateful to your lordship. So within that time limit, my lord.
Okay.
that not to create any third party right.
Lordship can do that because they said,
Right.
kind,
No,
no,
we are just we are discussing.
Lordship.
they have said, my lord, that they have taken possession.
This flat was the vacant flat. It was being utilized by anybody. Somebody has been thrown away.
Let me.
It was under lock and key.
Absolutely, my lord, just give me a minute. এই ফ্ল্যাটে কোনো লোক ছিল আপনি কি আপনি কাউকে দিয়েছিলেন? It was rented.
Rented, anybody was occupying.
Outsider কেউ ছিল? Family member? হ্যাঁ? Outsider.
Not related to the
Not related to. তিনি possession-এ ছিলেন? তাহলে outsider, my lord, it was let out to not the family members, to an outsider. She is in possession. Probably.
In possession.
Yes, that is what my instruction is. And possibly they have taken symbolic possession.
Physical possession has already been taken.
Most probably the flat is vacant.
forcefully material still inside, right? So भागीदार उसका सामान अंदर है.
My lord, the materials were inside. According to him, my lord, they have taken, entered and forcefully taken possession, whatever. Materials are there. The persons were, my lord, they were, my lord, asked to vacate. So obviously, bank's order, my lord, they couldn't do anything.
Order reflects forceful possession. It is written in the order that if it is in padlock, they will forcefully break it.
After hearing him, we will say that no third party right will be created and you can go and prefer an appeal, subject to what he is saying.
Lordships, my lords.
This is your, just wait for a moment, let us see what is his
Just one paragraph, my lord. I'm sorry, my lord. I wanted to show, my lord. See the contents of the notice, what they have said. Page 110, my lord, kindly comes to, my lord. My lords would kindly come to, my lord.
Yes.
My lord, kindly comes to last but one paragraph. That as per the court's order, in the case of objection, is found locked, even then the possession shall be taken by breaking open the padlocks as empowered by the Honorable Court. So it's like a forceful possession, what they have done. Materials, they couldn't bring it, but the persons were probably threatened to go outside. This is the nature of the notice. This much I have to say, my lord. And right of appeal, my lord, time period has not been expired, as what had fallen from Justice Mitra, my lord.
For the legal heir of the guarantor. Legal heir of the guarantor, my lord, who died in the year of my lord, name was Madhu Devi Kedia. Madhu Devi Kedia.
Devi KD. Her name is not there at page 111.
No.
Mortgager has expired. Mortgager was Madhu Devi KD.
Yes, Madhu Devi Kedia, my lord. I am
the guarantor.
No, my lord, I am the legal heir of Madhu Devi Kedia, who is the mortgager. My lord, I stand corrected.
Mother was the guarantor who passed away, legal heirs, my lord.
The layers means this Vikas Vishal.
Yes, my lord. Initially, my lord, we approached this honorable court, my lord, because they initiated proceedings under 13.2 and 13.4 against the dead lady. Now, my lord, initially there was an order of stay passed by the honorable single bench. Now, my lord, thereafter, when the writ petition came up for final hearing, my lord, it was disposed of since the bank said that they will not proceed with the original 13.2, 13.4, which was challenged in the writ court. Now, subsequently, my lord, in the year of 2024, again, they issued a notice under in the name of the dead person. There was a second round of litigation. My lord, we approached this honorable court by filing a second round of writ petition, where, my lord, we obtained an order of status quo. Now, that order not only granted us a status quo order, my lord, also restrained them from issuance of any sale certificate in favor of any person, and also granted us the liberty to approach the Honorable Debts Recovery Tribunal. My lord, we approached over there. There was a delay in filing for 1 day, and that's why the tribunal, my lord, rejected our application. We came back to the honorable court for the third time. That order of the tribunal was also set aside and the matter was again relegated back to the tribunal. Now, my lord, what happened in the interregnum, my lord, the matter got dismissed for default in the month of January 2025.
Dismissed for default.
Before the tribunal, before the tribunal, before the tribunal, my lord, it got dismissed for default. Now, my lord, on 24th of June, this notice for eviction, which was affixed on the 2nd of July in the secured asset, my lord, we came before the writ court challenging the notice under notice dated 24th of June. On the ground, my lord, our date of knowledge of the order under section 14 came on 2nd of July. So that, my lord, liberty may be granted to us to approach the tribunal challenging the order under section 14 under section 17 before the tribunal within the statutory time period as given in under section 17, my lord, of 45 days. Now, my lord, while dealing that, our writ petition was dismissed by the honorable court, recording that the petitioner was not diligent enough because the matter got dismissed for default before the honorable tribunal.
No steps for restoration.
And no steps were taken for restoration.
Sorry, last line.
My lord, no steps were taken.
Was affixed.
2nd of July, it was affixed. We approached the writ court on the 3rd of July. Leave was granted on 3rd of July. And the matter was listed before the honorable court on the 8th of July. The writ petition was dismissed on the ground that
But for stay of the section 14 order.
no, of the order of the notice for handing over possession.
24th June.
24th June. On the ground that it has come up to my knowledge on the 2nd of July. So my statutory remedy of preferring an appeal under section 17 says 45 days, my lord, so that I can prefer the appeal within a period of 1 week and not to give any effect for a limited time. Application, my lord, which is at page 35 of the
42 in my petition.
Well, it takes up page
Of
40.
the honorable single that is quoted. What a pattern look like.
No, no, সেটা তো প্যারা 13 এ।
কতগুলো এখন আসছে কেন? Copy দাও।
You did not include the other years.
I implemented the other areas, my lord. Only thing, my lord, what
But
mistake?
not the company.
Not the company.
Why, according to you, your claim was turned down?
Because, my lord, I did not take any steps before the honorable tribunal and the matter got dismissed for default in the month of January. And the petitioner did not take any steps, my lord, for filing any restoration application.
What
And
is your explanation to that?
my lord, I have explained my I have explained my case, my lord. There was a lack of communication and it's a fault on the part of the petitioner, my lord. She resides at Kerala, my lord. She could not take any steps, my lord, to that effect. I have pleaded that in the writ petition, my lord.
Yes, Mr. Singh.
Lordship, with due respect to your lordship, my first responsible submission before your lordship would be regarding the maintainability of the writ petition at the outset by the borrower, the company. Admittedly, the bank is taking SARFAESI action against the default taken by the
Yes, both
Can what?
without the certified copy and order, third party appeal, both.
lordship, may I? My first responsible submission before your lordship would be is that the loan taken by the borrower is not in dispute. The default in repayment of the loan amount is also not in dispute.
you have a person to whom you will be giving your sale conference. There has been no sale.
Yes, sale has, that is, they have suppressed. They are not placing the submission. The honorable judge taken cognizance that the sale certificate has been issued, it has been confirmed in view of the judgment passed by the honorable apex court in Bapna and Sanjay Sharma. Auction cannot be set aside if it is confirmed on only limited ground of fraud. Sale certificate has been issued, your lordship. I have handed over to the honorable single judge.
9th of May.
9th of May, sale certificate has been issued. 2024.
24 sale certificate.
Lordship, under the SURFACE Act, in terms of the provisions of the Act, Lordship, kindly take trouble to section 14. The bank can, in case of default of repayment of loan, what the bank will do?
Sale certificate was issued in whose favor?
Lordship, sale certificate was issued in favor of the auction purchaser, whose name is appearing. Lordship, in the middle portion, limited toward the finance secretary such as West Bengal. The undersigned acknowledge the receipt of 65 lakhs. Lordship, the name of the purchaser is appearing in the middle portion.
Handed over. Where is the name of the purchaser?
The name of the purchaser in the middle, Lordship, Mr. Sarva.
That is my,
Yes. Sir, I did not get even opportunity to go through the entire facts. I'm trying to assist the court.
Officer doesn't have not gone through it for 1 more year. It was on May 2024.
Lordship, kindly see, your lordship, by the purchaser in the PAN number of Madhu Devi Kedia.
Where you are?
The mortgager handed over physical possession. Your lordship.
Let us read it. The undersigned authorized officer, yes. Such and such. Security. Exercises of power.
In favor of Pankaj Agarwal. Yes. For an amount of rupees 65 lakhs and odd. 67 lakhs and odd.
9/5/2024.
Yes.
And thereafter the notice. If the sale had taken place on 9.
Please, sir, please. Kindly allow me to assist the court. Your lordship, the property has been auctioned. The three writ petitions filed by the petitioner, the legal heirs of the mortgager, 3 writ petitions have been filed before this honorable court. The honorable single bench taken cognizance if any sale happen, that will be abide by the final adjudication of the DRT proceedings. Lordship, they have approached who is the petitioner? Because I am challenging the writ petition filed by the borrower. Since till today they have not challenged either of the SURFACE proceeding filed by the bank, initiated by the bank, 13-2, 13-4, possession notice, auction. Yes, because the allegation is she was unaware. Admittedly, one of the legal heirs who is alleging is she was completely in dark what her case before the single bench. Her case before the single bench was, yes, the property is mortgaged with the bank. Bank has auctioned the property, but I am one of the legal heirs. I am entitled a sale. So my first question my first submission before your lordship would be, if you are asking for being a legal heir, I am entitled to accrue a portion in the property, then you have to accrue the liability as well also, because that was the mortgage with the bank. But in the writ petition, even before the DRT, in terms of section 13(8), your lordship, the 13(8) of the provisions of SURFACE had given a liberty to the defaulting borrowers to tender the money before the date of auction. And if you tender the money, you can redeem. They have not spelled out a single word about redemption. They have not spell out a single word regarding the liabilities of repayment of loan. The only case is, being a legal heir, I am entitled. So, Lordship, I was submitting before your Lordship is that the entire SURFACE proceedings, right from way back 2023 to till date, the borrower company did not turn up to challenge either of the SURFACE proceedings. I have ventilated before the Honorable Single Bench. Honorable Single Bench taken cognizance. You being a defaulter did not take any cognizance. Court is not supposed to give liberal view to such a borrower who is indolent, who is reluctant over their right. Lordship. Lordship.
And so as regards your opposition to the leave to appeal, we are not passing any order on that appeal.
Lordship.
But in respect of his appeal,
Lordship, kindly make my subject to Lordship, obviously.
have taken possession.
Yes. Yes.
Have taken possession, but we will hear the matter. We are fixing a date. In such time, you don't hand it over to anyone.
Subject to Lordship, obviously. Obviously, I'm bound by your Lordship's direction, but only I'm submitting before your Lordship is that with due respect to the Honorable Court, a litigant, unscrupulous litigant is not entitled to get any relief from the Honorable Court. So, Lordship, 3 read petition. How Lordship? Yes, certainly. But prima facie, I'm trying to satisfy even they are not entitled to get any interim relief.
What you will do within these 3 days? What will happen? Pankaj paid the amount of 67,000 way back in
67 lakhs, your Lordship.
Sorry, 67 lakhs way back in 2024.
Your Lordship.
It has been passed yesterday.
Lordship.
We are in CC of the matter. You come and tell us that leave was granted because they were of the thinking that it will be immediately taken.
Lordship.
That has frustrated.
Lordship.
So now we must go through the papers.
I'm not on that. I'm only on prima facie whether entitled to or not. Thereafter, Lordship can consideration. 3 writ petitions filed. Liberty was given to approach the tribunal. Lordship, I'm having the order. 3 occasions they filed a writ petition. First writ petition filed, 1 day delay. Run to the Honorable Court. Honorable Court, very well, 1 day delay is not a hurdle. Go and file. They have filed. Thereafter, the tribunal, in terms of the order passed by the Honorable Court, taken up the matter, but dismissed their application 1 day delay. 3rd writ petition filed. Tribunal's order has been set aside with the direction to take immediate steps for disposal of the application. Kindly see thereafter the conduct of the petition. Appellant before your Lordship. 24th July, the tribunal, taking cognizance of the directions passed by the Honorable Court, kindly, your Lordship, take the last 3 paragraphs. Applicant is strictly directed to prosecute the matter. He did not turn up on 24th July. Thereafter, your Lordship, on 26th September 2024. Whether he is entitled to interim relief at all or not, prima facie, Lordship, I leave it to your Lordship. On 26th of September, once again, they did not turn up. Oh, sorry. I tender apology, Lordship, because my phone was vibrating.
It was my
Tender apology. Lordship, kindly see 29th of September 2024 order. Once again, did not turn up.
Conduct is not.
No, Lordship, 3rd order. This is not. Kindly 3rd order, 28th of January. Once again, did not turn up, despite of the liberal construction given by the Honorable Court. 3rd order. The single bench taken cognizance of the conduct of the petitioner. Thereafter, speaking order was passed and dismissed. Now he is shouting before the Honorable Court that I was unheard.
No, he didn't shout.
Lordship. My voice is.
He didn't. You said he shouted.
My voice is biologically like this.
sale certificate.
Lordship, sale certificate. Lordship,
That was on 2024, na?
Lordship.
Kindly give the fourth line from the bottom. Do you have
Yes.
that copy?
I have, my lord.
Your copy.
His copy, he has given it to me. You know.
Yes.
After, my lord, just give me half a second's time, my lord. Just to read the
No. Mr. Singh.
cell,
Mr. Singh.
cell notice.
ठीक है.
The possession
But ठीक है.
sale certificate.
Lordship, the possession has been handed over. I have read. Lordship, this sale certificate is a prescribed format in terms of the statute. I am handing over. Even then, your Lordship, even then, with due respect, subject to your Lordship consideration, the bank, this is the statutory format. We will not be able to change the single word. It is in terms of the statute, in terms of chapter 5, rule 5 of the statute. Thereafter, even the bank, there are recent judgment of the Honorable Apex Court, bank can take physical possession even symbolically. But we cannot change the word of this. Thereafter, after issuance of sale certificate, bank is taking steps for physical possession, and the court is. The court has occasion to go through this.
Allow us to hear your contention.
I leave it to your Lordship. I leave it to. This was my submission prima facie. Even he is not entitled.
You will not be doing anything till Wednesday.
No, I will not. I will not. Certainly, I will. I will not till Wednesday. I will not do anything.
So we can record your statement.
Lordship, kindly do not record, but kindly assure, being an officer of the court, I am asking my officer to tight your hands.
We are not officers of the court.
Well, I am the officer of the court, your Lordship. They are not. Certainly, they are not. I will convey.
They got the intimation that the
Shouldn't have taken the possession.
fix the matter at 2 o'clock. If your officer is not an illegal,
Lordship, kindly see at what time.
you are taking a now, whatever may be the time. Once the officer hears that court is in ceasing, he should stop his hand.
But by with due respect, so that sir, Lordship, with due respect, Lordship, with due respect, I don't want any wrong message conveyed to the honorable court or impression. By that time, the entire process was concluded. They have left at 1:50. But by that time, entire process was concluded. Bank officials are agitating in front of the office, so they won't be able to enter. So he has taken possession and officially and thereafter.
But tomorrow if he comes and says that there was no interim order, I have given it.
No. I will convey, because kindly take statement of mine, your Lordship. I'll be conveyed.
Pass an order, I think that
Because if your Lordship pass any interim order, they will circulate every process, every judicial forum. Kindly see, this was the observation. This was because the instance from the earlier three petition where the court was liberal, not on merits. Court was liberal, but they are circulating in the appeal as well also. Lordship, kindly see the appendix 5.
And if we find that any further steps taken,
No, I'm taking responsibility of that. With due respect.
Kindly record, my lord, this. Otherwise, my lord,
we would have recorded. He's taking a preliminary objection as regards this conduct we have.
absolutely, my lord.
So we have to deal with his argument.
Absolutely.
That we cannot do without defining. It may be what he is submitting may not tally with something which is there in the lead petition. I do not know.
But
We
my
do
lord,
not know.
absolutely. But
So, and when he is our officer, he says
Very well.
we accept that. And
but the last,
if any third party right is created, that would be at the behest of the bank. We will take a
But sorry, my lord, last few words, my lord, lordship has noted, my lord, that it's not in his hand. Today's strike, somebody comes, takes possession, leaves.
Because
Don't shout.
possession only
He has taken.
goes to
Let them in symbolic
purchaser,
possession.
not to the third party.
It will have to be
Third party has already been created by way of sale certificate. Already been created by issuance of sale certificate.
You say it's a
Only handing over is left. I will not. I will not.
very well. That's what I'm praying before.
I'm giving an undertaking. I'm
That's
immediately
exactly
I
what
convey
I'm.
my office.
That's exactly what I'm praying, my lord.
Hey, Gupta ji ko bolo possession.
Mr. Singh, we are recording that we are
Let's see, I'm just conveying. Do not record, I'm just conveying. Just conveying, your lordship.
conveying what?
Conveying to the authorized officer.
No, but then
Do not hand over to the auction purchaser.
No, but we'll have to record something.
Lordship, because ठीक है, my submission may be recorded. My submission may be.
Yes, we also don't want to embarrass you as our officer.
But can you record my submission? Record my submission.
Record your
Yes, record my submission.
Yes. No, say first টাতে কোনো order pass করতে
First is yours.
It's mine. Second one is ours.
Oh, your second
Company.
first টাতে তিনটা ওই যেদিনকে রাখবো সেদিনকে সেকেন্ডটাও রিলিজ করে you have given all copies and everything.
Yes, served.
Private respondent
কাকে দিয়েছি ভাই? Sir, I have to verify because 11th hour what they have handed over, I gladly accept. একটু আমাকে ভালো মতো সাজিয়ে দিয়ে দাও, নাহলে বুঝতে পারবো না।
এটা তো রিটটা পারবে।
হ্যাঁ,
এটা কোম্পানির অ্যাপিল।
আচ্ছা।
Appeal has been preferred.
My lord is keeping it, my lord, with leave of my senior. If my lord is keeping it next Monday, by that time the order should be in the sun.
No, no,
Trial court's order.
keep it on Wednesday.
Very.
Next Wednesday.
Lordship.
Very.
On that day, the file will also come. You also come ready. What of the we hear and dispose of it.
My lord, only one indulgence, my lord, I'm seeking, my lord, from my lords, my lord. I may not be in town for the entire week, my lord. If lordships permit me to do it virtually, my lord. This is
Virtually is a.
then, my lord, kindly, my lord, keep it after 9.
Are you going for the whole week?
My son has got admission, my lord, in VIT, so I have to be there, my lord, for 1 week.
Lordship,
12th and 19th, any day after 19th, if lordships, my lord.
Auction purchaser threatening us, if you will not hand it over possession, we will proceed in accordance with law. And nowadays, your lordship knows, because after sale, bank is under obligation to hand over. That predicament is also in front of our office.
On 21st, subject to my lord's kind convenience.
So that whole week you're not there, 14th till 19th.
19th, yes, that week, my lord. If my lords permit me to do it virtually, my lord, I have no problem. Otherwise, kindly, my lord.
Mr. Singh, can you wait till the 21st?
Let's say, let's,
No.
what, I sell.
Huh?
I sell, your lordship.
Better be grateful to me.
Yes.
Without 21st.
This appeal has been preferred by
Lord, it's a specially assigned matter, my lord. Original side.
Specially assigned.
Specially assigned, my lord. It's
Speciality about the matter.
my lord. There are two connected appeal, my lord. This is concerning appointment of the court recording officer of the original side.
This is a
Matter pertaining to officer appointment of an officer of court recording original side, my lord. My lord, there is an order of the single bench, my lord, which has been stayed. The appointment has been stayed. The appellant before your lordship is the successful candidate. There is an order from the learned single judge bench which has stayed the operation of the appointment process. That was passed in September 2024. Agreed by that, the High Court administration has already preferred an appeal.
what is the urgency?
Well, the urgency, I am the successful candidate. My appointment has not, I have not been favored with the appointment procedure, my lord. There is an appeal connected pending by the, preferred by the High Court administration also, my lord. That has also been assigned before your lordship. This is the connect. My lord, the
Let us see what can be.
my lord, I'm
Shown
also handing over the order which will reflect the connected appeal.
has been completed by the us also today day for reply Mr. Sara in appellate side matter. If your lordship
Your problem.
yes ma'am yes ma'am. If my lord not heard the appellate side matters today, then my lord kindly appellate side matter past and interim matter. That interim matter can be modified.
And we are not taking up that matter. We are taking up the original.
No, my lord. What happened, my lord? In appellate side matter, there is an interim order.
Yes.
But showing that interim order, so many licenses have been stalled.
For that also we will say that why have you stopped it?
Because my lord, in the
What is your prayer today? Tell us.
today my
Bandyopadhyay is not.
I am not on that, my lord.
What, then tell us what you are on.
I am on, if my lord, you will see, had the original side matter, you will can hard. I don't problem. But my lord, in appellate side matter, there is in appeal, there is a interim order. Before the land.
We are asking, can we fix those two matter because those 2013, 2001, because all those control orders were equal. If we separate,
Both the repetition.
If we separately here, you want it to be analogous?
Yes, both the
issue are not same. Let I place my case.
In the repetition point is same. In the writ petition, vacation notice was challenged on the gap of then control order lost his force.
It's absolutely different. What is his problem? I fail to understand.
This problem arises. Tell us when your senior will be.
No, they have concluded their submission. I shall take only half.
Can we do this thing? We will let him complete his argument, but the matter will again appear on the day we will hear the appellate segment. You have no problem. Do you have any problem with it?
He has every problem in every matter.
Problem is there only one problem, my lord. Showing the interim order passed in appellate side matter before the single bench, matter is pending before the division bench. No license can be granted.
He has also moved that petition. He has also obtained the interim order, relying on this division bench judgment.
How can he say that?
Well, Mr. Sara appear for the client, I am appear for the client. In one matter,
sir, we have heard you.
I shall not take more than half an hour so far this matter is concerned.
Mr. Sara, your argument in reply in the appellate side matter
not yet started.
Also awaited.
Yes. That will take much more time because there are state and Sushobhan Sengupta, private respondents. But so far this matter is concerned, I shall conclude within half an hour. This is a simply manner different question of law. Let I place my case. Within half an hour, I shall conclude my submission. What is the problem? The interim order has been granted by the coordinate bench.
In the appellate side.
Yes, my lord.
You are really seeking a modification of the order, interim order, which we passed in the appellate side matters.
Yes.
What interim order did we pass?
Interim order passed. No dealer tag be deduct from the distributor. No ration card would be deduct from the dealer.
That order was passed by us.
No, Justice Joyamala Bakshi, other bench. 2 years back.
That order is continued.
Yes.
That order is continued. If my lord, your lordship.
So have we said that order is continuing? Now we will, when we finally hear the appellate side matter, we will take note of that. But how this will prevent conclusion of this matter? We are wanting.
Because my lord,
suppose this matter, we may pass order against you or against him. We have to pass an order. So if we suppose he emerges to be successful in this matter, will that create any problem for you in the,
No,
the other
absolutely
matter?
not. Absolutely not.
problem is only one problem, my lord.
This matter can never be heard till the appellate side matter is heard. It can never be heard. You are saying that no, you have to
No,
hear both the
no,
matters
That's the only intention.
no, that's mean, my lord. No, that's mean, my lord, appellate matter cannot be heard.
Why? I shall start today itself.
Have we recorded any order that there will be analogous hearing of both the
No.
matters?
No.
Sir, please apply your mind.
Issue is separate entirely.
We dispose of this matter. What problem you will face in the appellate side matter?
Appellate matter, we face only one problem, my lord. Because so many petitions come after, showing that same point pending before the division bench.
Very good. You can tell us that you finish up that matter earlier, first.
No, that's my submission, my lord.
That we will fix up a date of the appellate side matter. Why you are standing in the way for him to complete?
No, my lord, today also appellate matter is fixed.
Then we will release the matter. When you are so much insisting.
No, my lord, no.
When you are so insisting. Today, appellate side matter, it is our discretion whether we will hear it today or not.
I am said fixed, man. I am not saying you must be taken up this matter.
Yes, we have already fixed it today also. Today also we have brought the appellate side matters in the list. It is not that we are keeping the appellate side matters just in the chamber and we are continuing with this original side matter. If that matter interim order is modified or not, এটাতে দেখো না কোনো appellate side কোনো analogous hearing.
No, never.
Let us see. No, দেখি file.
The issue is entirely separate. If I can show to your lordship how and which manner they don't want this matter will be heard. An existing interim order, separate writ petition.
Any order that this original.
No.
Because matter from the day both the matter appear together. These matter appellate side, these matter original side, and appellate matter original side. First matter appellate side.
Existence of that interim order in a separate writ petition.
Concluded by the both of state also my side.
Without making us party in the original side. An order has been procured, I must say. Because entirely different issue.
Appellate side matter, it's not possible to dispose of that matter on a particular day. We have to give you opportunity of hearing. We cannot assure you that we can dispose of the matter on the next day.
But so far,
asking you, suppose that we will continue its fashion. We will fix up this matter we can conclude. How you will be agreed by that?
May I start, my lord? Or may I start?
You're disturbed. Your reply in appellate side is complete.
Only I shall give reply.
Huh?
They have concluded. All have concluded. So far appellate side matter is concerned, reply is required from me.
So Mr. Shardai, give us a date. We will fix
Any day. Even tomorrow, I have no difficulties. I don't want to stand on the way. Your lordship, kindly take up this matter and any day. Nothing.
Any order disposing of any order passed in this matter, how will it affect?
Then, my lord, why I am saying so? In the writ petition, challenge is vacancy notice issued in terms of 2013 control order.
That is appellate side.
This matter also.
This matter in his writ petition, he has not implicated.
Has not implicated, absolutely, my lord.
writ petition has been filed. The challenge.
Tell us, if we dispose of this matter separately, what will be your problem? We are giving you so much of time because of this reason. We don't remember whether we said that we will hear these two
No.
analogously. You are not being able to tell
No,
us.
I am not saying so, my lord.
So if we dispose of this matter, will it create any problem for you? Tell us.
Then, my lord, you will also go to the main writ petition.
Oh, now we have to tell you what we will go into.
No, my lord, in the writ petition, challenge is same in appellate side matter. That is my point. Same.
Please satisfy us how.
Kindly come to the order improvement. Yes, 106. Kindly come.
How it is, how this matter will affect the decision of the appellate side.
Kindly turn to page 100. Improving order. Just go through it. He cannot show. In this case, what happened? I obtained an interim order.
Let him still, yes.
Only to drag the matter.
Lordship, kindly take the writ petition of Sujata Mitra in appellate side.
This matter, original side matter.
My lord, what I own in appellate side matter, Mr. Sarah client filed writ petition challenging the vacancy notification on the ground. The vacancy notice has been issued in terms of 2013 control order. Since 2013 control order lost its force after 2015 central control order come to effect. Learned single judge, that time one matter is pending before the division bench. Same point. There also Mr. Sarah appear, I also appear. Learned single judge, when passed the interim order, Mr. Sarah restitution client could consider that the same point involved in the MAT, earlier MAT, and interim order was passed not to give it license till the disposal of the writ petition.
That is in this matter.
In the writ petition of the Mr. Sarah client. In the vacancy notice, my client successful client. A letter was issued.
Not want to go into any problem. We want to discharge our duty and finish.
Kindly allow me 5 minutes. Kindly 5 minutes. Allow me 5 minutes time. The facts of the case is entirely different. Just allow me 5 minutes time. What?
When you are ready with the reply in the final matter, on that day you finish it off, give your reply here also.
So for this matter is concerned, if you also kindly give me 5 minutes time. What happened?
Yes, we will give you time. We will hear the appellate side also, Mr. Shah.
Since in this matter they are holding the license, they will say before the court that both matters are identical, and your lordship will adjourn the matter on the basis of their submission without hearing me. That entirely different issue I can demonstrate before your lordship within 5 minutes. 5 minutes. Just I am telling before your lordship. I obtained an order in the appellate side challenging the vacancy notices. Got directed not to fill up vacancy. In the order, it has been recorded that an issue involved also issue in a division bench matter. But the learned single judge
Shall hear you, but we will keep the matter along with the appellate side matter on the next day. Let him come and say.
why he is saying, since he is saying,
Because we do not remember, because when the matter was taken up, once it went, we said that if we dispose of the original matter, the challenge against the order passed by the single judge in your main matter, whether that will suffice or not.
that will not, because my issue is that he obtained an order from the learned single judge.
All right, place your argument.
My lord.
Let us consider.
Just 5 minutes. My lord. Well, kindly turn to page 40. Page 40.
Page
40. Stay application. There is a vacancy notice dated 1st September 2022. Middle portion, first paragraph, kindly say block Raiganj, subdivision Raiganj, page 40, annexure P2. District Uttar Dinajpur. Stay application. Not so good copy, Mala, kindly read. Middle portion, first paragraph. The location of the vacancy at Raiganj block, subdivision Raiganj in the district of Uttar Dinajpur. Have you also got, my lord? This is 1st September 2022. But we, the two appellants, are the MR distributor of the same area. The proposal was that this vacancy after appointment, dealers will be dealing from me and shall be tagged with the newly appointed distributor. We challenge this order for the learned single judge. If you will kindly come to page 46. This is the order passed by the learned single judge, which still exists. Page 46. Kindly read, my lord. Whether this order has been passed relying on the division bench order or not. This is the only issue involved. Affidavit of service file, all the parties are represented. Heard the counsels for the parties. It is pointed out on behalf of the learned counsels for the parties. Who are the counsels? Advocate General represented, state represented, petitioner represented. It is pointed out on behalf of the learned counsels for the parties that the same issue is being deliberated upon by a division bench of this court in MAT number so-and-so. The next date in the case has been fixed on so-and-so. This is recording submission. Next.
You have made this submission.
Yes.
Said that this is coterminous, not with the mat which has been mentioned.
Yes. So all parties, not only me, state also submitted. Next paragraph.
But he was not a party there.
No. Because he has only applied for in that material pointer.
The only point was you said that this is coterminous with mat 296. This order.
Yes. No. Next paragraph. Let this matter come up for hearing so and so. The party shall be liberated to file the written notes of submission on the date. Kindly take note this paragraph. In view of the point taken by the petitioners that under the Central Contract 2015, there is no provision for distributorship, let the respondents not finally appoint any candidate in respect of the vacancy notification in question. However, they shall be entitled to otherwise propose with the selection process. Well, this order means that this order has been passed relying on division bench order. Does it mean?
So then it is the 2015 contract.
Yes, that's the in view of the point.
So that is the subject matter in the
Now you also kindly come. What happened? So this order has been passed in a view the point taken by the petitioners that under the central control order. Does it mean division bench judgment has been relied on? Only submission has been recorded. In every order, there are three parts: submissions, findings, order in portion. Findings of the learned single judge is in view of the point taken by the petitioners.
So then what is your argument that as
this order still exists?
This has not come to an end with the dismissal of the MAT 940.
Absolutely. Because MAT 922 says all points left open.
Now this 2015 control order, the dispute which has arisen, that is also the subject matter of the appellate side.
Kindly take note of. They filed a writ petition during existence of this interim order. This is not the issue today. This interim order exists. Appeal has been dismissed on the ground of locus, saying all points are left open, including the point which is the subject matter of challenge in the writ petition.
Interim order was challenged.
My lord.
Which interim order was challenged and dismissed on the ground of locus?
My lord, kindly come to the division bench order at page, my lord.
That is not in connection with this WPA 115.
No. But that was the submission before the single judge by filing a fresh writ petition without making us party that this interim order gone. That's the subject matter of issue. I shall show you the no connection with the other matters. It has been submitted behind the back of our knowledge without making us party. This interim order has already expired. Kindly come to page 100. May I read, my lord?
Yes.
The instant writ petition is filed seeking direction upon the concerned authority to issue license in favor of the petitioner in respect of vacancy of distributor at Block Raiganj under subdivision Raiganj in the district of Uttar Dinajpur. It is the case of the petitioner that by Deputy Director DDPS issued a memo on so and so contending inter alia. I'll kindly come to my next paragraph of the memo dated 8 June 2023. But in view of the interim order of the Honorable High Court in WPA number so and so, have you also got, my lord? This is the order passed by Justice in my writ petition. The state of West Bengal so the license in favor of the approved applicant shall not be issued till disposal of the said writ petition. The state also understood that unless that order is vacated or writ petition is disposed of, license cannot be granted.
Yes.
This has been done after division bench also. Now next paragraph, kindly come. It is the case of the petitioner that an interim order was passed in WPA number so and so. This is in absence of us. We have not met with party. In view of the pendence of the appeal being so and so, the said appeal has been dismissed and disposed of. Is it correct? Is it correct? In view of the pendence of the appeal.
That is how you are interpreting.
Yes.
Your order also refers to that man.
Submission. Kindly come to page 46. Only submission has been recorded.
The judge has held that it is coterminous with the MAT 96.
Taken your lordship, kindly take page 46.
Now it is an interpretation of the order which has been.
Yes, if the division bench says we are keeping all points left open, including the point taken in the writ petition, I are dismissing the appeal only on the ground of.
Take an application for extension of interim.
Where?
You made an application.
Extension of interim order? Never.
Yes,
Never.
that was shown to us.
No, this is an application for appropriate order. Why?
No, an application for addition of party you made for getting inside that litigation, and you have made an application for extension of.
No, never. Never.
This is what I was.
Never. Never.
Kindly.
There's no need. An application for appropriate order. Why I'm saying, suddenly we find that license has been granted. We don't have any knowledge. Because this order has been passed behind our back, saying that there is no interim order. So we filed an application for appropriate order so that.
Passed behind your back.
This order, the interim order, page 100.
This 100, that 30th January order.
Yes.
30th January order, the memo which was interfered with was quoted. The court observed that in your writ petition there is an interim order.
Yes.
After that, the court observed.
Kindly take note of. In the case of the petitioner that an interim order was passed in view of the pendence of the appeal being so and so, then Mr. Bandapathy, learned senior advocate appearing on behalf of the petitioner, submits that there is no embargo to issue license in favor of the petitioner, as there is no such interim order for issuance of license in favor of the petitioner. This is behind our back. Justice Joyshun Gupta passed the order until further order. There was no mentioning that the interim order will be continued till disposal of the appeal. Had I been made party, I should have disclosed before the court that this is the situation. My interim order has been interfered with by another bench in a coordinate court, in a writ petition, without making me party. On a simple ground of non-joinder of necessary party, this order should go. Nullifying an order of the other bench, another.
File the application for appropriate order.
My lord.
My lord, filed on 10th February 2025.
10-2. After coming to 10-2. কোনটা বলো? আরে 10-2 রিপ্লাই নাকি?
Page 23.
Kindly take note of page 23, an application for appropriate order.
Come to page 29 of the opposition. See the prayer ones.
Yes. Why I'm saying so?
When did you file it? On 10th of February.
Immediately after granting license. Immediately after granting license.
10th of February 2025.
My lord.
3rd March.
Behind the back, they obtain an order.
And the appeal filed on 28th of February 20.
My lord.
So, Mr. Sarai, why it cannot be said that you are also aware on reading of the order that the interim order is over?
Subject to lordship consideration. What happened?
Please take us to the averments. What?
My lord, my lord, my lord.
This is a stumbling block, na?
My lord, your lordship kindly come. Paragraph 4 onward. Page 26. All of a sudden, I found that license has been granted, despite existence of the interim order. My application I have filed so that the cards may not be detached from me. Dealers may not be detached. Your lordship kindly come to the order impugning which.
That may be one explanation. Yes. We are wanting to know, Mr.
Then I am submitting one thing.
A black and white statement to the effect that please extend the interim order.
Can you take up? Just your lordship kindly take up my reply. I shall show only one document. Kindly take up my reply. Just take up my reply. They have filed an application for addition of party after passing of the order by the Honorable Division Bench. In my writ petition, knowing fully well that the interim order is still there, they filed an application for addition of party. After passing order by the Honorable Division Bench. Kindly take note of my reply. Kindly come to my lord, page. Kindly come to my lord, page 10. When this has been affirmed, page 10, an affirmation page at page 18. After division bench order, knowing fully well unless the interim order is vacated, they cannot get the license. Affirmation 25th September 2024.
Mr. Sarai, this argument of yours that from the order it would be explicit that the interim order will continue till the issue of 2000.
That is their case also.
2000.
Hence, my lord, after division bench order, immediately they could have filed a writ petition. Instead,
that your main thrust of the argument is on the order, that the order, reading of the order will send you a message that this interim order should be subsisting till 2015.
Your lordship kindly come.
Not mitigated.
If your lordship kindly come to the division bench order, one paragraph.
Yes,
Lordship kindly take up my stay application. My lord, page 48. Page 48 starts. If your lordship kindly come to page 54.
The order would repeal.
Your lordship kindly see the division bench order, one paragraph.
We are
Page 48 is the division bench order starts. Your lordship kindly turn to page 54. They are relying upon this division bench order. Page 54, second paragraph, I am reading. This is the division bench order.
That was only on the point of locus.
Locus saying all points are left open which is pending in the writ petition. Even if my wrong action can dilute a court's order. Even
so today, if we are in your favor, then the interim order will stand revive and continue till the disposal.
That is still there. That has not been affected.
Then I think, Mr. Sardai, then we should hear the appellate side matter along.
Kindly take page 54 first. One paragraph.
Remove all hassles. We also want to get rid of it.
But there is no whisper so far the learned single judge order is concerned. I should have made party. That's my only issue.
Which portion?
Page 54, second paragraph. Since no decision has yet been taken, the right of the appellant does not appear to have been infringed, and therefore the plea of person aggrieved does not appear to be sound and logical at this stage. The concept of person aggrieved originates on a principle that if an order is passed in a proceeding between the litigant affecting the right of third party who is not implicated in the proceedings, such third party may assail the said order before the higher forum upon seeking leave to appeal. The grip of aggrieved has to be judged in the context of the decision taken by the original authority or the court of first instance on the basis of the cause of action pleaded therein and the tenant of the ultimate decision. Merely a proceedings is initiated and the ultimate decision does not affect the right as to a final decision has been taken. Is in this case, the appellant cannot be said to a person aggrieved to maintain so and so. Since all the points, take note of, since all the points are kept open, including the point of locus and having held to the applicant does not have any locus of a person, we do not venture to decide the other issues raised in the instant appeal. We have been given to understand that several litigations are pending. Kindly take note of. Pending in the docket of the court in relation to the distribution of system within state of West Bengal on various grounds, including the grounds which have been taken in the instant appeal. Therefore, it would be apposite to record that those points shall not be treated to have been decided as in instant appeal in expressly. Since our judgment is restricted to locus of the appellant to maintain the appeal as person aggrieved, therefore all other issues are undecided and kept open, and if taken any other proceedings, it be collateral or otherwise shall not be constituted to have been impliedly decided by us in the instant appeal. Since the held as the person aggrieved in view of the natural so and so, the implement of so and so. So that point which was stated equal to total.
So this এই ইস্যুটাকে রিজলভ করে কি সেটা একটা লিকেজ থাকবে কারণ
does it says, my lord, that dismissal of the appeal takes away my interim order? That's the only submission before the learned single judge. I am reading page 101.
Mr. Sardai, today if we hold in your favor, then the vacancy declaration pertaining to 2015, which is under consideration in the other litigation, which according to him we should hear out.
I am only praying before page 100 quashing the order passed by the learned single judge holding that there is no interim order.
No, right. If we today your contention is to be accepted, then if this interim order has to continue till the disposal of decision on the issue of the control orders of 2015.
But subject to lordship consideration.
This is what we are.
What is the state is also supporting me? Kindly take up state's opposition.
That you have shown us.
State is saying no, interim order is still there.
Then we are keeping a date. You come that matter argument you finish and
You lordship kindly take note of only one point, Mike.
One point you are arguing is that you say that it is guided by the 2015 control order, which is
that's other part. Appellate side matter. My case here is that, my lord, whether this writ petition should have been moved ex parte without making us party or not. Whatever may be Justice Joyson Gupta passed an order, that order has been nullified by a
that prima facie you are showing that I was not a party to a proceeding in which you have obtained an order against me.
I am the worst affected party.
So right, you are this we are talking about the nexus. Today, if we decide in your favor, then your distributorship will continue till the decision.
No. They have given the dealers from other distributor also.
That has been
my distributorship also continuing. Now some dealers from me, your lordship kindly. I fail to understand, my lord, why they have moved it ex parte without making me party. That's the only issue. I ventilate before your lordship, this petition should have been dismissed on the sole ground of non-joiner of parties.
That also turns back to the issue of survival of the interim order or not. Why will I make you a party when I find from the records that the interim order has gone away with that MAT 296 matter?
MAT 296, that is their finding.
That is their argument.
Yes.
And your argument is no, you are conscious that there had been an order in my case.
They are also conscious because they filed an application for addition of party after dismissal of the appeal. Kindly take note of.
Mr. Sharda, you conclude your argument in appellate side also.
May I? Yes, that's true, my lord. May I give?
I assure you this much that we will keep time to you. You finish it or we conclude. Let us conclude the hearing. We are also not concerned with this. It's who's the
My order has been interfered with.
That the file was dismissed and disposed of therefore.
Even after passing of the division bench order, state filed an affidavit before the division bench. Kindly take note of this one. Only one paragraph. Kindly take note of.
Yes.
Well, I'm reading from page 4, paragraph 3. Subparagraph A. A fresh MR distributor vacancy was initiated by the District Control of Food and Supplies, Uttar Dinajpur. Vide memo dated 4th June 2012, the vacancy was notified by the Director DDPS. Accordingly, one Sujan Chandra Rai, the respondent number 1, that's my management plan, applied, approved. Then B, before issuing the license in favor of Sujata Rai, a writ petition, that is our writ petition, was filed before the Honorable Court at Calcutta, and Honorable High Court passed an order in this matter, wherein it was directed the licensing authority not to issue the MR distributor license in favor of the Sujan Chandra Rai till disposal of the said writ petition. Kindly take note of my affidavit page. And then next paragraph. Thereafter, Sujan Chandra Rai filed a petition being WP number before the Honorable Court for vacating the said interim order. It is a state case. Unless this interim order is vacated, license cannot be granted. It has been affirmed, kindly see when it has been affirmed. On 20th March 2025, before the division bench. The state case, we cannot grant license unless interim order is vacated. They have written it, the approval letter also, till disposal of the writ petition. Then how this writ petition has been moved without making us party, and why the state has not submitted before the court that this is the position? Is it not collusion, my lord? State submitted before the single bench, we are ready to give license, and affirmation affidavit is that saying interim order till disposal of the writ petition. Is it the way to move a writ petition? Page 101.
Appreciate your argument, Mr.
Your lordship, make it CAV, deliver the judgment along with that matter. Hearing conclude.
Why? What is your problem?
No, I have no problem because I have concluded my submission. They have also concluded.
So we will deliver the judgment.
Absolutely.
If you finish off your appellate side matter also, both the matters we will deliver the judgment. That is what we have
No,
tried.
I am saying, my lord. No, I am saying since your lordship is proceeding on the basis of submission of my learned friend, who was the faulter without making me party.
No, Mr. Sada, we are not proceeding. We have just now criticized you. We are not on that. In the backdrop of the mind, sometimes, maybe in earlier hearing, we have said that as the main issue involved is in the appellate side matter, we shall hear that matter, and as such, we directed it to be disturbed. Otherwise, we have not. Why should we think? I have discussed with my brother because it may have slipped my mind. I don't know. For this reason, it is not for any other reason. We wanted to shift it off. That matter also argument you have made your argument. They have given the reply. You have to give a reply to us. And the state additional argument has been made by Mr. Sengupta.
Your lordship, kindly fix a earlier date, my lord, because we are suffering. Thursday রাখলে হবে না। আজ দরজা ফ্রাইডে রাখো, শুক্রবার তো থার্সডে হবে না।
না থার্সডে ওখানে তো
থার্সডে অরিজিনাল সাইড তো।
Yes, tell us. 21st we are.
Yes, ma'am.
your appellate side matter and this original side. All right, no adjournment, nothing.
My
You
lord.
inform your senior if he wants to let him go.
I shall only conclude my submission. Possibly, learned senior will not come, as I understood, because they have concluded their submission.
Concluded their
All.
submission. He will give us.
I shall only give reply.
And we have heard Sengupta also. So they, nothing more.
Nothing remains except my submission. Nothing.
Only Mr. Sar has replied.
Now he is happy. He is running the business.
তুমিও তো ব্যবসা করছো আমিও করছি
But 21st at 10:30.
21st at 2 p.m. we take up. You're in a problem.
I don't have any problem.
Then any.
No, 10:30 it can be also. I'm saying so that I can conclude, if
How
possible.
much time will you take, Mr. Sir?
I have to give answer to Mr. Bandhopadhyay, Shishana Bandhopadhyay, Sushomon Sengupta. They have delivered so many judgments.
Let us keep it at 2 p.m. Part chance, if you cannot finish it, we will continue on the next day. At least we can make some progress, and this is.
I shall try to conclude, my lord.
So if you can conclude.
My lord, item number 1, 2 p.m.
That is why we called you and said, Mr. Sarda, today we have fixed one appellate side matter due to these actions. 21st এ দুটো সময়। Appellate side matter টা 22nd ঠিক আছে,
21st 2 p.m.
21st
Original side matter will also appear on that day.
original side matter you have called.
Let it appear.
Yes, yes.
কিন্তু 21st জুলাই দুপুরবেলা তুমি খাওয়াবে
Sure, sure. Kanchan.
এই original side matter টা একটু অর্ডার শিখতে দাও তো।
You would understand. The end of the 31st evening. Yeah. Reminder intimate is still 31st. Right? But in the appellate side matter, intimate is still 31st. Intimate is still 31st.
Yes, 21st we have kept. 31st it is there.
July.
We have heard Mr. Sarda.
ইম্পর্টেন্ট মামলা এগুলো সব
One submission on my part. On the last occasion, my lord, the learned advocate general made a passing reference to a new act being Revocation of Incentives Act. But if the state relies on that act in this present appeal, then the situation is different. If the state doesn't want to rely on that act, then the situation is again different. So, my lord, I want a clarification from the state whether they want to rely on the act or not to rely on the act. Because if they rely on the act, they cannot proceed with this appeal.
Either way, we have to hear Mr.
Yes.
But my lord, kindly record, my lord, the statement of the state, because I am telling your lordship, This is one of the matters. And these matters will not end here. It will not terminate here. These matters are going to travel to Supreme Court under any circumstance, my lord. So, my lord, let it be recorded that the state either wants to rely on this act or doesn't want to rely on this act in this appeal.
What will be your action if you
But
say
if
that-
the state relies on this act, then I have a point of demurrer regarding the maintainability of the appeal. If the state doesn't want to rely on the act, then it's okay. Then Learned Advocate General is making his submissions. He can continue with his submission.
if he wants to rely on the act, you want to address us first?
Yes, yes.
Yes, Mr. Dotto, what do you say?
There are two things. First is, Millard, a statute has been brought in to withdraw all the schemes, all the incentive schemes from the date of the promulgation of the respective schemes.
Mr. Ratul বিশ্বাস, you have not given us that chart also. Sorry for the interruption.
I'm preparing the chart, my lord. My lord, a huge volume, my lord. I'm just preparing, my lord. By Friday, my lord, I hand over your lordship.
We give you till Monday.
I will hand over you.
It was on Monday. You have to please mention the total number of applicants. 44 applicants, na? Please give the chart. All of your friends are here.
Yes.
My lord, I given my lord an application.
No,
Like this way.
all the appeals, na, whether they have all preferred leave to appeal.
I got your.
Our confusion was whether anybody directly went to Supreme Court or not. That
I will
was-
indicate that.
Please, so that. Yes, Mr.
But one is, Millard, the schemes, respective schemes, including the present scheme, it has been withdrawn with retrospective effect. Therefore, the question, there will be twofold question. One is
To be withdrawn from the date of
Yes.
then what happens to all the benefits which have been doled out under that act, on the scheme?
Millard, there is a provision to claim back those. Yes. Whether the state is going to exercise that right or not, that is a different question. But there is a provision.
Yes.
This is number one. Number two is, Millard, that rightly or wrongly, Millard, there is a judgment in this proceeding. My first endeavor would be to get rid of that judgment on the merits of the matter. On the merits of the matter.
Then you will not be relying upon.
No, I'm not going to rely.
Then
That is not required to be recorded.
Because it is required to be recorded.
No. Then you file an application saying that because of this, the appeal
No,
becomes
my lord.
infructuous.
My lord, if during the course of hearing, suppose my Mr. Dr. Learned Advocate is making submissions that there can be refund of tax, etc. That is one point that we will deal in our own way. But my lord, if the state relies on this act, the act says that all the proceedings would stand abated. All the orders would stand negated. It's an act nullifying the effect of all the orders, all the judgments, everything. And no proceedings can be carried out in any court. So if the state is proceeding with this appeal, in spite of this act, then the state is not relying on this act. One, if the state is proceeding,
If that act they rely upon.
yes,
Question of challenging the act, why is of that?
that's not that is a different issue. I cannot challenge the validity of the act.
First say.
No, my lord, I'm on different. Perhaps I could not make myself clear. The validity or otherwise of the act, I cannot challenge before your lordship. It cannot be done because this is an intra-court mandamus appeal. But my lord, whether the state can continue to proceed with this appeal, having regard to the express provisions contained in the act, that is my point of demur. Having regard to the provisions contained in the act, if the state says no, very well, we will not rely on this act, and a statement is recorded on behalf of the state, if that submission is made, if no reference to the act is made, one thing, my lord, we will argue. If the reference is made to that act,
Act exists as it is today.
yes,
This appeal becomes not maintainable.
yes, that is what I'm on.
But let him place the act where how it is not maintainable. If he wants to argue this point, let him start with.
No, first we want to understand from the.
I have said, my lord, I am going to argue this matter on its merit. That is the validity of the order in itself.
But then, Mr. Dutt,
No external aid in support.
but the act remains, na?
No, act definitely.
Then this proceeding becomes
But that this proceeding may not become infructuous or abated.
right.
The proceedings will. No, I will.
Was that how?
Milord, I will not make this submission. May I put it in one sentence? I will not make this submission that since this scheme stood withdrawn from its inception, therefore the order is bad. I can make a submission before the learned single judge and say that your order is not enforceable. That I can say
That
before
is
the
there,
learned
that is-
single
that
judge,
is there, that is
relying upon the statute.
Right, that is there. So, my lord, now, my lord, then, my lord, we reach a kind of moiety. Moiety in the sense, my lord, when this contempt petition will be taken up. Contempt petition is slated for hearing when? 11th. Then they will take the defense of the legislation.
Is there anything in the act by which you can avoid that act and proceed with this? Have you given a mind to that?
No, on that, Milord, I have not looked into, but I don't think, subject to correction.
What is coming in our mind if you make a substantive argument in this matter and state wishes to proceed with that act, then it becomes an academic issue, na? Whether we will go into this matter or not.
Milord, yes.
If I may say so,
Yes.
that if you can apply your mind. Please apply your mind to that, and if you find that yes, this has been the state policy, then question of hearing the matter, this entire proceeding goes, na?
Milord, may I say this, but I cannot come before the court and say that my appeal has abated.
That is what your act says.
Yes.
No. All proceedings for execution, claiming benefits, etc., those will get abated.
This is continuation of the writ. Continuation of the suit. This is an
Here,
appeal.
Milord, Mr. Mazumdar's client is not in the before the appeal court.
My lord, what they will do, I tell your lordship, what we apprehend, the state will argue on the merits regarding this appeal. And when this contempt will come up before the honorable single judge, then they will show the act. Now that we have enacted this legislation, kindly
That hurdle you have to overcome.
that hurdle we will overcome. But my lord, I cannot be subject to a double whammy. That is what I'm on. I cannot be subject to this kind of proceedings, my lord, when the act clearly says that nothing survives. Nothing survives. No litigation survives.
You make your reply to the argument of Mr. Dutt.
My lord, I will make, my lord, whatever Mr. Dotto has submitted, learned advocate general has submitted. My lord, learned, if I have correctly understood the submission of the state, that the judgment, they want to test the judgment, not on the basis that the incentives to withdrawn from the date of inception of the scheme, if I am correctly understood. Now, my lord, then, my lord, it is the stand of the state, so far as this appeal is concerned, that the act does not apply. That the act does not apply. That is what I'm on. Let it be made clear.
No, why, Milord, please consider one thing, Milord. I may succeed in this appeal. I may not succeed in this appeal. If I succeed in this appeal, the question of enforcement of the order will not arise of the learned single judge. If I do not succeed in this appeal, the question of enforcement will arise. Once the question of enforcement arises, which is still there before the learned single judge, because I don't have a stay, I don't enjoy a stay in this proceeding. At the time of enforcement, I will rely upon the act.
That is what I'm on.
I am not here to enforce an order of the learned single judge.
But there is an application for stay before your lordship.
Yes.
It is being
there-
heard.
Yes. Application for stay or deferment of the order of the learned single judge.
Well, the submission of the state is like this, that they are making the statement
When
before
has
the
the act come?
The act has come, Malad, the act, that was very strange in fact. First, the bill was published. Nobody knew when the act was, Malad, was passed by the legislature. Only when, Malad, in sometime in the month of May, we came to know that the act has been passed or enacted, gazetted on 2nd of April. In the month of May, all the entrepreneurs in Bengal who were availing the incentives came to know that their act has already been enacted. And my lord, take it from me, my lord, several entrepreneurs, several industrialists made representation in the meantime that don't proceed with the bill. They were not in the know of the things.
Where is the scope to make this representation? It's a legislative action.
That's a question. That's a
Tomorrow
question.
if something
My
will
lord,
be
I am
discussed
telling
in
your
the
lordship
legislature.
on
I
4th,
cannot say that don't enact a law.
on 4th of April, 2nd of April, this act has been passed by the legislature. I take it. This is the date of commencement of the act. The act has been specifically given retrospective effect. The act takes away the benefits under the schemes with retrospective effect from the date of inception of the scheme itself. Now the state comes and say before your lordship that so far as this,
We will not allow him to argue. It is understood because he is on his appeal about the validity of the order.
yes,
This will
Malak, kindly make it clear, because I know when this matter travels to Supreme Court, this will be one of the ground if we succeed.
No.
Then they will say that there was an act.
Then he has to make an application.
No, Malad, why
not
should
an
I?
oral
Malad,
submission.
why
It's
should
my
I-
appeal, Milord. It's my appeal.
So, Mr. Mujumdar, that idea
Kindly take the provisions of the act for once. If it appeals to your lordship that the act does not stand in the way, then it's a different thing.
No, you formally bring this to my notice.
Malad, I cannot bring. Malad, I cannot. Why should I invite trouble for myself?
You use a short opposition.
Malad, kindly take for once. Malad, why should I invite trouble for myself? Malad, I am before your lordship. I have succeeded before in the writ court. Malad, the state is in appeal. Malad, no, Malad, it is the duty of the state to point out. It is state's act. It is state's enactment. It is not my enactment. It is not my legislative action which is to be brought before the court. It's state's enactment.
Mr. Dotto, you use a supplementary evidence, bring this on record. Proceed with it.
Very well. Kindly do not record anything, but I'll file a supplementary appeal. No difficulty. Yes.
Do we record that or
No, not required. But only let there be an understanding, because the contempt would be
Malad, that understanding remains, Malad, I assure learned advocate. But this understanding is continuing for last 1 year. It will continue for next 5 years. We all know. রুল তো আমরা তো করে দিয়েছি,
ডিসপেন্স হয়ে গেছে।
ডিসপেন্স হয়ে গেছে। আমরা এটা এইগুলো করে এগুলো করা যায়।
সময় বলছি না। হ্যাঁ,
শোনা যাবে
না, বাড়ি যাও। চলো, কি বলবো আর কি?
2 and 3, my lord, is analogous, my lord. 2 and 3.
চলো কি করবে
Okay, reply-টা দিই।
রিপ্লাই দিলে দাও। Would you lordship take it up next week?
Let the reply be taken on record. Opposition and reply.
But only one thing, may I make a humble request? Would you lordship take up before Wednesday any day?
Mr. Sannal, we are
But now I tell you, Lordship,
aside matters.
I understand, but
Don't
difficult.
know much.
Well, difficulty is that I'm hard pressed because before the learned single judge. Learned single judge view, unless you get a stay, I will proceed. This I submit the next day. Earlier occasion I also submitted. Your losses directed direction for affidavit. My learned friend says my learned friend didn't want any direction, but your losses passed direction for affidavit. Now I am before the learned single.
কবে আছে?
Suomoto contempt will issue.
No, there is no, we have not till
Filed, they have not filed. I have showed in the earlier occasion also.
Order has not
And
been
what happens,
applied.
your lordships? This matter will be taken up Wednesday. Your lordships will be taken up at 2 p.m. This had happened on earlier occasion also.
No, we are sitting on, we will be taking up this bench for
Next Wednesday again.
16th to.
And this has been kept on 16th rate petition also.
You are the culprit there also. What can you?
Well, then that's the situation, your losses.
We keep it immediately on 16th. This will be the first one.
But 16th in the morning, this will be taken up, read petition.
No, after 2 p.m. All original side 2 p.m.
But tell that Mr. Sannal, we have kept it on that day. Keep it on that. The order sheet.
দেখি দাঁড়াবে
আমাদের রেডি নেই, একটা কপি করে দিচ্ছে।
সে দিয়ে দাও না। Repeating the same thing.
Have it. Difficult situation.
Anyhow, that's the views we have to.
আর তো আমি খাচ্ছি।
কেন আমি দিয়ে যাচ্ছি না?
ওখানে ঘাড় আমি খাচ্ছি।
You are filing what?
So I will file a reply to their opposition.
You are filing just now.
No,
No, you will file opposition.
I will file opposition. Sorry, sir.
May I file a reply, my lord? I have subbed
Oh,
copies.
reply is also there.
Yes, my lord. And I have subbed already the copy within the time
Fine.
stipulated with by your lordships.
ধরেন একটা কপি করেছে, দুটো কপি করে দিতে
সাদা কপি দিয়ে দেন।
হ্যাঁ, সাদা কপি দিলে হবে না।
Suomoto is that's I've never said anything to him. That's up to what the court says. Unless you get a stay, I will proceed on the next. This is the last chance. And we intimated that today is taken up. That's why my matter has been kept 1 week after. Now today it could not be taken up. That's why matter has been kept in 16th. শুনানি করতে গেলে সময় লাগবে এখন।
কাজ করে না Even to detention bench, embarrassing. আপনি অরিজিনাল সাইডে স্টিচ করে দেবেন
আমি নি একটু শুক্রবার ফ্রাইডে নিই এভাবে মামলা করে লাভ হবে না আর কতটুকু সময় then losses take it up on Wednesday at the top your losses because I find your losses time because I will take little time I will cite 2-3 judgments
Yesterday is the your that OBC matter is fixed.
no 14th if I'm not wrong
No.
14th
No,
16th
16.
14th primary matter oh OBC is 16th
OBC is 16. আচ্ছা let it be there it will be আমাদের লিস্টের টপে রেখে দিও it will be his lordship হ্যাঁ
এটা সময় লাগবে স্মল স্টে দিয়ে ছেড়ে দাও না Keep your place, madam.